I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yes.
Concrete had damaged petals. We are the roses. We would all love its will to reach the sun. Well, we are the roses. This is the concrete. Don't ask me why. Ask me how.
Bitches are plenty, handling semi, sipping Henny. I hustle for pennies, know my own fear by many. I watched and took notes as a child. I strategized, witnessing no hope, it's no peace. We've got lies. Niggas don't know me, but they think that we could be closer than homies. Nigga, you phony, so quit buying drinks. Mind on my money and funny about my currency. Niggas don't wanna see me, but they bury me, living in jail. Prison is hell for a nigga, they using my bail. Been bigger jails for a nigga. Father, I'm feeling tired, forgive me, cause I'm a sinner. Living like it's a dub, while ducking cops and the criminals, homies is dead brother. Past times are gone, you ask why I drink liquor, cause my mind is gone. And if I die, doing life plus two, we living to die. Everybody's high, put some high too.
Tell me, baby, would you ride for me? Bust on the motherfuckers when they lie to me. No, don't you never tell a lie, just confide in me. Would you die for me? Tell me, baby, would you ride for me? Tell me, baby, would you ride for me? Would you bank on them niggas when they lie to me? Don't never tell a lie, just confide in me. Would you die for me? Tell me, baby, would you ride for me?
I'm stressed out, nigga. Poke my chest out, nigga. Wait on my shoulder, bring the best out, nigga. Get it right or you get left out, nigga.
Would you die for me? Tell me, baby, would you ride for me?
It's clearer now, cause I'm a new day individual, but some are gone. Not just a small time criminal, times have changed. Homies died, only lives remain. Massive amounts of narcotics help me hide the pain. We shitting on the kids, came up on the jag, then got it out for the quiet times. Reflect on the past, on my homeboys that didn't make it. For you, I do it, remember back in the days as young truants. Telling me to beware because you can't help me to be prepared. Cemetery full of homies no longer here. But what about the babies? Lost and watching burglars, living like it's a dub while ducking cops and the criminals. Homies is dead brother. Past times are gone. You ask why I drink liquor, cause my mind is gone. And if I die, then let me watch what we've been through, living to die. Everybody's high, put some high too.
Tell me, baby, would you ride for me? Bust on the motherfuckers when they lie to me. No, don't you never tell a lie, just confide in me. Would you die for me? Tell me, baby, would you ride for me? Tell me, baby, would you ride for me? Would you bank on them niggas when they lie to me? Don't never tell a lie, just confide.
All right. So we're going to get this broadcast started. We're going to do a quick flashback. You know how I do. I like to get the audience up to par. So let's get this on the screen real quick. I want to say blessings to you and happy holidays if you celebrate it. You're here with Grace Levi today on this amazing day. And we're going to get back into the YSL trial. All of the drama, Judge Glanville. We're going to get into the ex parte transcripts today. But before we do this, let's let this play for you guys.
Of the YSL a RICO trial involving rapper Young Thug is in, limbo after a motion to take this case away from Fulton County. And 11 like Grace King is explaining why the defendants want a judge outside of the county to weigh in.
to not to take the plea bargain.
All
So
right,
they're
we about
going
to
to
start
trial
that over for
very
you
soon.
guys if you got no
But,
sound. Let's go.
Well, tonight, the future of the YSL RICO trial involving rapper Young Thug is in, well, limbo after a motion to take this case away from Fulton County. And 11 Live's Grace King is explaining why the defendants want a judge outside of the county to weigh in.
What I want to know is why wasn't I there? Why, sir, I'm going to hold you in contempt.
After weeks of tension, Judge Ural Glanville letting someone else decide whether he should stay on the YSL RICO case or recuse himself after allegations of improper conduct during an ex parte or private conversation between Glanville, prosecutors, and Lil Woody, a witness who refused to testify on the stand. The meeting did not include defense attorneys.
This is a really serious and scary moment for everybody involved in this case. It could spell the end of the state's effort to pursue justice, or it could lengthen the already longest trial George has ever seen.
Criminal defense attorney Joshua Schiffer, who isn't involved with the case, says the question now is who's qualified to make that decision. Fulton Judge Belinda Edwards immediately recused herself after being assigned the case, and with a new motion, the attorney for Diamante Kendrick is hoping Judge Rachel Krause will do the same.
It's alleging that due to Judge Glanville's existing relationship with the rest of the bench and his behaviors in this specific trial, there's no way an independent ruling can be issued by anyone in Fulton County.
Legal experts tell me time is of the essence because this case already has a jury attached to it. Judge Krause gave the state until July 8th, this Monday, to respond to those recusal motions. In downtown Atlanta, Grace King, 11 Alive News.
All right, thanks to Grace for breaking that down for us. This is a trial that 11 Alive has been following since the very beginning. To keep up to date, to catch up, or to learn more about our coverage, head over to our website, 11alive.com, and just type YSL in the search bar.
Police in southwest Atlanta are investigating an overnight homicide. It happened on Peyton Place Southwest, which is not too far from the Hamilton MARTA station. Police tell Fox 5 crews they found a man in his 20s shot and killed inside an apartment there.
The person identified that was shot in southwest Atlanta was a close friend of YSL Woody. Now, the guy name is YSL Tate, and there are rumors circulating on the internet that somehow the Wham tweet that Young Thug dropped on Friday is somehow connected to the YSL Tate shooting that happened in southwest Atlanta this past week. And also on Friday, there's been a lot going on. YSL prosecutor was back in court on Friday, and YSL defendants was in court, and they had to enter a plea bargain. All YSL defendants decided to not to take the plea bargain, so they are going to trial very soon. But a lot of people are talking about that this YSL Tate shooting that took place in Atlanta over this weekend. He was inside his apartment when shots rung out, and he didn't make it. He's now deceased. And YSL Woody took to Instagram saying he will revenge his death. And a lot of people are saying that the tweet that Young Thug dropped on Friday is somehow connected to this shooting that took place in southwest Atlanta when Young Thug dropped a tweet. Someone from his account dropped a tweet on Friday saying whatever Wham says goes. And a lot of people are saying that Wham is Lil Baby. So a lot of people are saying that someone from Lil Baby account carried out a hit on YSL Tate in order to silence YSL Woody because he's a close friend of YSL Woody. None of this, the accusation can be confirmed at this time, and but a lot of people, like always, spreading news that somehow Young Thug is involved in this YSL Tate shooting that took place over the weekend. How he can do it from jail and not get caught I don't know. But they're saying this tweet, this random tweet, was a signal to the little baby to go ahead and carry around a hit on YSL tape. I'll keep you posted on any more updates. Please subscribe, hit that like button, see you soon.
An altercation overnight, Friday, June 28th to Saturday, June 29th, resulted in one person losing his life.
Junior Drive, officers said they found a 31-year-old man shot several times inside an apartment. He was already declared dead. Atlanta police are not giving us many details tonight, but they say this shooting stemmed from a fight outside. No word though on what led to the gunfire or the search for a suspect.
Apparently, the victim was someone close to YSL trial witness Woody Copeland.
Police are investigating a death in southwest Atlanta. Happened early this morning at an apartment complex. Channel 2's Brian Mims is live on Peyton Place. Brian, police say the shot was fired from outside of the apartment.
Exactly. There is a big police presence here at Peyton Place, just off Martin Luther King Jr. Drive. You can see the officers still on the scene after more than 3 hours. The call came around 3 this morning when officers showed up at an apartment at 9 Peyton Place. They found a man in his early 20s who had been shot to death. It's unclear if anybody else was inside that apartment, but police say there were no other injuries. A man, again, in his early 20s, found shot to death inside an apartment at 9 Peyton Place. They do say the shots came from outside the apartment, from the street, but it's unclear if the shots were fired from a passing vehicle or whether the suspects were on foot. Police don't have any information at this point about any suspects. They have been interviewing a number of witnesses on the scene. In fact, we have seen a large crowd of people gathered at the Texaco station right across the street from this apartment complex. Investigators have been talking with these folks as well as folks inside the gas station, but right now, very little information about what led up to the shooting and little information about any suspects. Live along Peyton Place in southwest Atlanta, Brian News, Channel 2 Action News, Saturday AM.
Brian, thank you.
Previous speculation was that the victim was identified as Tay, a man who Woody had previously identified as the man who shot at him. Woody later said on the stand that he did not know who shot at him.
Going back to the incident in which you, your girlfriend at the time, and your child was being shot at, do you remember seeing any of the individuals who shot at you?
I never saw no one that shot at me at that time.
Do you recall in that interview a period of time where the detective left the room and you were speaking with your girlfriend and you told her that you knew who shot at you?
I never saw nobody. I never saw who shot at me. If I saw who shot at me, I would never told the police who shot at me.
Do you recall in this same February 20th, 2021 interview that when the detective left the room, you said to your girlfriend, this shit not gonna work. Sit right here and be a damn snitch, so I'm gonna keep going. Do you recall telling your girlfriend that?
I don't recall.
Okay. And then she responded, so, right, it'll be effect on them.
I'll rule the objection, sir. I'll rule, sir.
So, what you're saying, White acting like you did, and she said you should have just said no. I thought you know all of them, and you said to her, I do know who it was. Do you recall telling her that?
I know that I knew the camera. I knew that I was being recorded, so I kind of knew what I was doing.
Okay. And then you said I saw him. I did when he jumped out the car. I know exactly who I saw.
Nobody never got a car, so it's clear to prove that I knew what I was doing.
Do you recall telling your girlfriend that?
I don't recall what I told her.
Okay. And this was when the detectives had left the room.
I don't recall if they left the room or if they stayed in.
Do you recall further in the interview when the detective asked you whether or not any of the people who did this had ever been to your home, you instructed your girlfriend to tell the detectives who had recently been at the house?
I don't recall what I told you.
Do you recall the detective asking anybody you let come over to the house recently that normally ain't been by there? And then you told Deshaun, tell them who been there. Do you recall that?
If I brought anybody to my house, I'm 100% sure they know not to play with me.
Do you also remember when you and your girlfriend were in the room by yourself, you told your girlfriend it was Tay and them who did this to you?
I don't recall.
Was it Tay that shot at your vehicle?
I don't believe so.
Do you recall in that same interview being concerned about being labeled a snitch?
I don't care about what I'm being labeled as.
The trial is currently undergoing numerous hearings before Woody is set to take the stand again. It is not clear how this most recent incident may affect Woody or the YSL trial.
During this time when your home was when you were being shot at with your daughter and your then girlfriend, how many other family members' homes have been shot at that year?
I'll sustain as to speculation. I will overrule as to hearsay from Mr. Steve.
To your knowledge, how many of your family members' homes have been shot up back in 2015 after Nut died?
Overrule, sir.
When he let me go, I didn't come back with the gun, so they sent the SWAT team to my house to get me.
But when you went the first day, did they ever put handcuffs on you?
Because they wanted the gun.
Did they ever put handcuffs on you?
Yeah, and answer the question.
Did they ever put handcuffs on you?
One of the officers put them out, and he told me we don't need that.
Okay, so they never put handcuffs on you?
Overrule, sir.
Did they ever put handcuffs on you?
I don't think so. My daughter's life, when that car pulled up on me, all I saw was a gun come out the window. They said I never seen no one face. They was questioning me. They constantly kept telling me, you gonna let dudes shoot at you and your kids and this and that, and I'm telling them, and they won't believe me that I'm telling them I didn't see nobody's face. I didn't see nobody's face. And then after a while, I got tired of asking me, so I don't recall if I just went ahead and said, yeah, I seen Tay. I don't know how it came out, but in my heart, and still to this day in my heart, I do not believe Tay had anything to do with me being shot at.
Do you recall telling your girlfriend when it was just the two of you, I did when he jumped out the car? I know exactly who I saw.
I don't, at that point, it was so much pressure on me. Yeah, I'm a daughter crying, trying to take her to the hospital. Somebody pull up on me soon. I'm trying to figure out what made me have a gun, go to the hospital. It's all type of stuff going through my mind. I don't know. Too much going on. Yeah, I can't, because she keep asking me these questions and.
Just take a breath, okay? We do need to take down your testimony, so you do need to speak a little slower, all right? Okay?
All right.
Bare assertions and legal conclusions which aren't sufficient for the court to grant your motion at this point in time and refer it to another judge for it to be heard. So I'm going to deny the motion at this point in time. I invite you all to look at Baptiste versus the state. Just because adverse rulings have been made doesn't mean that the court stops the trial. So I'm going to make that. I'll reduce both of your of the motions to recuse to an order, and I will file that so you can take whatever steps you need to necessarily after that.
Brian Steele responded, putting Judge Glanville and the prosecution on notice.
We assert, not a bare assertion or a legal conclusion, but we make facts that we specifically adopt from the Honorable Attorney Winchester, Collins, Banks, Nove, and Mormon's motion, where a person that they represent was in a meeting ex parte with the court and others, and the prosecutor and a witness, and specifically they wrote in the pleading and under Parish, P-A-R-R-I-S-H versus State, which is 362 Georgia Appeal, 392 Division 1, 2022, the lawyer's pleading on behalf of the client becomes a statement of the client. And they said that this court got involved with speaking with Mr. Copeland and assisted in Mr. Copeland testifying against Mr. Williams. So I've added this court to the witness list. I plan on calling the court as a witness in the trial. I've added lawyers Hilton and Love from the district attorney's office to the witness list. And when I cross-examine Mr. Copeland, when that day comes, I'm going to ask him about how much pressure, if any, the court put on him.
Police shooting in Southwest Atlanta happened early this morning at an apartment complex. Challenges Brian Mims is live on Peyton Place. Brian, police say the shot was fired from outside of the apartment.
Exactly, and police say they don't have many details about what led up to the shooting, but there is a big police presence here at Peyton Place, just off Martin Luther King Jr. Drive. You can see the officers still on the scene after more than 3 hours. The call came around 3 this morning when officers showed up at an apartment at 9 Peyton Place. They found a man in his early 20s who had been shot to death. It's unclear if anybody else was inside that apartment, but police say there were no other injuries.
All right. Now let's get this broadcast started. Let me put myself on the screen, y'all. Welcome. And let's put myself on the screen. Blessing, guys. Welcome to round 2 with Grace Levi, your hood court interpreter. Yes. Where we make this kind of dialogue, subject matter a little bit more spicy. We put more things together to make you see the whole picture. We try to hit topics when it's at its climax. Excuse me. I do apologize. When it's at its climax. And again, what we talked about yesterday for 3.5 hours, we do know that we are at another climax point on this YSL trial. So I want to say thank you for everyone who is tuning in. We are trying something new. We continue to push this channel. This session or this particular broadcast is under urban politics, okay? So we bring you news, Atlanta news that have to do with different corruptions across the United States. We've been focusing on Dalton and Thornton Township with all of this shenanigans related to Tiffany Henyard. So on this holiday, we're going to focus in again on Fulton County. And let's put her on the screen, the big boss, Madam of Fulton County, that has all of this going on under her. So what we showed you was a quick flashback. I hope you guys got a picture of what went on. We went over yesterday, and now we're going to present a few things to you today. Okay, so let's get this broadcast started. We're going to get a word from our sponsors first, and then we're going to get this broadcast moving. Thank you so much to my mods. I love you. Thank you for the support. Please hit the like button. Happy holidays.
Imagine if my small business blew up overnight and I woke up to some sales. Boost this video so people who like my products can find me.
Algorithm. Where you at, bitch? Because I'm tired of posting viral content and getting 2.5 likes. We finna fight, ho.
All right, now let's get it. That was a word from our sponsors, Lashlays. That's our second sponsor on this page, where we focus on health and wellness, passive weight loss. We have waist trainers, workout wear, and we also have a new line that we dropped called Miss Bougie Apparel. So you'll see some of that coming up in the near future. I want to say thank you so much for supporting. Thank you. So let's get it there. What we're going to do is actually put on the screen an update from one of my other favorite lawyers, okay? Even though I talk crap, there are some amazing people out there. And this lawyer right here, I follow him on Instagram. I do subscribe to him. I ask for you guys too. Lawyer for Workers, okay? So the day before yesterday, he made an update, and then he also made an update today. So, excuse me, I want to get him on screen. Please excuse me, guys. I know I'm like cleansing. So like I told y'all, I've been drinking like lemon, ginger, and spinach. So it's been making me a little gassy and my throat a little itchy. So please excuse me, okay? Bear with the process of the cleansing. All right, so let's get this on the screen. This is what Lawyer for Workers have to say.
Well, I can tell you, we've now received a copy of the transcript. The judge has released the transcript. Remember, this case is going to another judge to decide whether Judge Glanville can continue to hear this case. That other judge is probably going to look at this transcript, and what he's going to find is a couple of very interesting things. First, the prosecution asked for that meeting without ever stating on the record why they needed the meeting. Second, the judge said he wanted to have a hearing that morning to decide whether or not Copeland was going to testify, and that should have been done in open court. There's no explanation in the transcript as to why this was done behind closed doors. And that's very important, because if you watch court yesterday, the judge was on the stand building a record, writing everything that he did down for the record. So as the case goes to another judge, the other judge can see what happened. And one of the things that Judge Glanville put on the record is that ex parte meetings are appropriate when there are concerns about witness safety. However, there's nothing in that transcript about witness safety. Instead, the witness, Kenneth Copeland, discusses how he's afraid of being charged for other crimes, how he's afraid of being charged for federal crimes, how he's afraid of being charged for murder, and that for all those reasons, he wants to plead the fifth, how he's afraid of being charged if he lies on the stand, how over and over again, all of his concerns, nothing about witness safety, nothing that would suggest that the meeting has to be held in secret. That conversation, when you read the transcript, could have been appropriate if it happened in open court, not behind closed doors, without defense attorneys present, with 2 investigators from the DA, 4 sheriff's deputies, 2 prosecutors, and 1 judge telling the witness that you're going to sit in that jail until the end of this trial, until the end of 12 more defendants as part of this case who are going to go on trial. To me, when you read that transcript, you see no explanation for why it needs to be ex parte. You see all those people in the room, and you read what the judge and the prosecutors are telling them about how much time he's going to do in prison. It seems very clear that the judge is very interested in getting this witness to testify. He's not neutral. He's the government. This is a government witness, and the judge wants the government witness to testify. And that's not the job of a judge. Point blank, period. The job of a judge is to be the neutral arbiter of facts, of law, not to decide that, oh, I think that the government is right, and so I'm going to help the government by pressuring one of their witnesses to testify. Whether or not this ends up in a mistrial, we will see. Want to know what the...
All right, you heard it there from Lawyers for Workers. He gave a great synopsis, and everything he said is literally what we're going to be going through today in detail. We're also going to be going into the actual Gainesville order. that he put in. We're going to listen to that video. We're going to kind of respond to that. And then we're going to get into the ex parte. Just know that everything I show you is more so in synchronized order of events that actually happen. So that's what makes this so amazing, because you're going to see it unfold in front of you. Okay, so I kind of bring a lot of timelines together, and I just hope you enjoy it. So one a few of the things that we're going to highlight here is that the judge originally denied his motion, still motion to stop the trial, recuse himself. It was 2 motions put in, and it's not the first time they have put motions in to get this man out of there, and he simply threw it out just in the beginning. So we showed you that in the first clip where he was just like, nope, this is happening. No judge, nobody's going to oversee it, this, that, and the third, even though we know that that is what's needed, and that is the law. Okay. Now we're showing you how Fulton County gets down. Welcome to urban politics. All right. So the motion to recusal was originally denied by Judge Gainesville. Also, what we're going to get into, we're going to read the motion to recusal, so that we're going to read Still's motion. We're going to get into Gainesville order after the motion, and then we're going to get into the ex parte communication. So as Mr. Lawyer for Workers was saying, such amazing man, please go to his Instagram page. I think the key part of this is that there is simply no explanation on record as to why this meeting was held at secret. Without that, I don't see how the judge or prosecutor can defend this meeting. Now, with that goes to say, we're going to just put back on a little clip that we put on yesterday. And that was actually Miss Bumpus saying something similar. Okay, so let's get this. Shout out to the attorney for this clip.
I talked to him. We. Mm-hmm.
Okay. And so then y'all are just kind of killing time, waiting for Woody to come to the courthouse.
He comes in, and I guess, Glanville does this, whatever he calls what he takes judicial notice of, where he gives the timeline of what happened. So pretty much what he says is about the truth. I talked to him, but, I don't really remember what he said the timeline was, but there was lots of back and forth, in and out, back and forth. Like, some things he stepped out on because the state didn't want him to hear. And sometimes everybody stepped out just so me and Woody could talk.
Oh, this is interesting. So.
Wow. And, there were in and out moments of everyone. Mm-hmm. But the meeting was, I was like drained. And that's exactly why I kept saying, what am I in contempt of, when I came on a couple days ago? What's the contempt? I don't understand. You're mad because of what?
Right. If he never advised you guys of any type of confidentiality.
And Georgia law requires that if a judge wants to keep any type of hearings confidential, there has to be an order, whether it's oral or written. There has to be an order that specifies what has to be held confidential.
Becoming a transformational life coach is a sacred call.
Then Woody gets in there, and y'all are all in there talking. Now, there were some specific statements that were alleged to have been made in some of the motions to recuse. So, for example, Woody said allegedly that he was not going to testify and that he was willing to spend 2 years in jail not to testify in this case. Can you talk to us a little bit about that statement? Was it made? Kind of what was your feeling about it when you heard it?
When I heard it originally, or when I heard it recited?
when you heard it originally and at the hearing? I'm sorry, at the meeting.
I mean, he just was confused about what was going on. I do agree to a certain extent that the meeting was held to explain to him what immunity was,
Mm-hmm.
And the type of immunity that he was given. But I just think that in the process of it, there was information that came out, which then gave the defense a right to know about.
Did it seem odd to you when you looked around the room? I think at one point you mentioned that there were 14 people in the room. Did it seem odd to you that there were no defense counsels in the room?
Well, like I said, it was all happening so fast. And I think it was actually maybe 12 or 13. I can't remember the exact number because I couldn't remember how many deputies. But like I said, even though it was 2 hours, it was happening so fast. And I really didn't even get to think about that. I was just there for him. You know, he was asking me questions. He was so concerned about what was going on. And you know, I was just really there for him. But also it never gave the impression that it was a secret meeting either.
Got you. And let me give a big shout out to Talk That Law. Thank you so much, Talk That Law.
All right. So you heard it there. That was from the attorney's page. She did a full interview with Ms. Bumpus. Check it out. I'm going to put that at the bottom of my description. As you see, I'm kind of just putting some things together so you could get a clearer picture and kind of hear it in real time. So Ms. Bumpus even assumed that this meeting was not secret. So even if she went to tell, it was the second person to tell, as they say, the other lawyers, the defense team, it was not secret. The second thing that they really highlighted a lot is that Woody had concerns. There were some talk about not only criminality, but having some outsized concerns for his life that we showed you yesterday. Again, another thing that was highlighted here is that when it comes to competency, we're going to listen to the transcripts. We're going to read it together, and we're going to listen to where you hear clearly that Woody is confused. Excuse me. Y'all hear that thing beeping in the background? Hold on 1 second. I told my son, turn off the stuff because I'm going live. We're going to hold on. Give me 1 second, y'all. Okay. Always getting on my nerves. This is a little short minute clip, 11-second clip of my son. Guys, thank you so much because you know I'm live. That's my son. We'll put his brand up. We do sponsor. He's my sponsor too. Okay. Sometimes when I wear his clothes, I put his brand up. So that's him who didn't turn off the daggone alarm on the oven. Okay. So let's get back to it. Love you guys. Thank you for your patience. So again, what I was saying is that there was an expression of being fearful from Woody, as well as a level of incompetency showing. Not saying Woody's slow or anything, but regardless, if it was an act or whatever people say, he expressed that in the documents, and you can hear him clearly not understanding the difference between purge and perjury. So we're going to get into that. Now, Ms. Val, what I'm going to do, since I have more energy, since I'm going on 3 hours before, I'm going to read the transcripts myself, and we'll see when we get to the 50-something page how I feel. Okay, so we're going to get into it so I can bring it into real time a little bit more. Do you think that's going to be a little bit better? And then when I find a good voice, I'm going to pre-record it and have everything ready. How about that? Does that sound like a plan, Ms. Val? And it says I don't hear it in the background. You couldn't hear it? You couldn't hear the sound? Okay, we'll fix it if you didn't hear the music in the background. And I appreciate you. That's my boy, Hebrew boy. Get on my daggone nerves. Anyway, so where are we? We talked about a few things that happened yesterday. What we know was going on right now as we speak. YSL trial on hold. Judge Glanville faces recusal following secret meeting with witness. Okay, so let's just read. I'm gonna read this little article to you, and then we're gonna show the actual read of the order after all the drama that he didn't want to put on the stand. This is right before he's going to release the full ex parte transcripts, as well as put the case on hold and schedule for the actual hearing for still incarceration, possibly incarceration, with another lawyer. So this is where we're at. We're going to highlight that. And I do believe that they have another judge, correct me. And I do believe that they chose another judge. So we have another update from Lawyers for Workers that's going to highlight some of that information, okay? So the drama continues in YSL 100-day trial. After its initial start, Judge Glanville announced that the trial will be put on hold until another judge decides if he should be recused. The motion to have Glanville removed from the trial came from Young Thug attorney Brian Steele, who spoke out on June 10th after the ex parte meeting between the judge, prosecutor, and witness. Steele was upset that the defense was not present at Gainesville and the prosecutor's question and witness Kenneth Little Woody Copeland during the private meeting. Gainesville wanted to know how Steele found out about the meeting, but Steele refused to give up the information on his sources. Ride or die, Steele. I love you, boy. As a result, Gainesville held Steele in contempt and ordered him to report to the notorious Fulton County Jail. Okay, so when I put this picture up here for you guys, this highlights the Fulton County Jail. I'm not being fictitious. We're going to put a few of the videos in the description. That woman, that was the video I meant to show the picture. While that woman actually literally goes after Trump using Fulton County's money for some type of like national trial, and her jails is like this. Okay, I still have to, I'm very passionate because they literally lock people up in Fulton County for traffic tickets, for misdemeanors. You will get in there and not see a judge and face what Woody was about to face. When you hear the transcripts, they sound like they were going to lock him up indefinitely. Okay. So we're going to get to that. Welcome to Fulton County Jail in Atlanta. All right. So let me just continue to break this down. This isn't even the first time the highly publicized trial was placed on hold. In December 2020, Gainesville suspended proceedings after defendant Stillwell, remember this, talking about the Fulton County Jail, you saw all the knives? Shannon Stillwell was stabbed multiple times inside of the Fulton County Jail. We highlighted that. Stillwell is facing multiple charges, including 2 counts of murder, 2 counts of participating in criminal street gang activity, 2 charges of possession of firearm by convicted felony, previously convicted felony involved in the use of a possession of a firearm, and possession of a firearm during the commission of a felony. And with that possession of a firearm and commission of a felony, it is a mandatory up here. I think they did 10 years. And I found that out a couple of months ago, and we highlight that. They given a mandatory 10 years, right, for possession of a gun in the middle of a felony. And I do believe, don't quote me, I believe it's misdemeanor level, but I have to verify that. And you don't have to even be using the gun. The gun can be in your possession, in your car, somewhere around you, while you're in the middle of maybe an altercation, and you will get a mandatory 10 years. This is how our system is working out here. So that law actually happened shortly after they took away the restrictions on gun license. They stopped Georgia from requiring people with gun license to have them. You could just get guns out here, and this is when that law came into effect. And I was like, oh, they're trying to lock people up. So it may be right what I'm saying, because I said, listen, when Biden and Kamala gets into the White House, I said this years ago, they're going to lock everybody up. And I said, oh, hell, do we deal with the racism, crazy racist people, prejudice, or we deal with this, everybody getting locked up? And this is what's going on. You can see cases across the United States. RICO has been something popular under Biden. They're trying to take groups in troops of people down at the same time. I don't think they even have enough jails in the United States to hold how many people that they want to face with RICO charges, okay? They're going to keep on going after different organizations. We're just going to keep this real, okay? I know I kind of went to the left. We kind of got to talk about law here and some of the aspects of it and how it can affect us, okay? So right here it says Stillwell, the person who got stabbed up in Fulton County, the Guantanamo Bay of Atlanta. Stillwell is still being charged along with Young Thug rapper. That means that Stillwell survived, okay? And that is what's happening in that jail. One of the things I highlight, they don't know how to deal with their gang violence. Hold on one second. They don't know how to deal with their gang violence out here, okay? When these individuals get locked up, they are just meshing them together. And that is dangerous. We're going to have many young people not come home because of gang violence and them not knowing what's going on. Imagine going into a jail and you know what I'm saying? Even if a cop go into jail, he's part of a gang. They're not going to put him in general population. And they put these kids in general and these young men in general population, and they're fighting and warring and stabbing each other. Okay, I just want to highlight that is what's going on in our Fulton County prisons. It's a prison because you may not come out. It is a jail, but I consider it a prison. Like many people say, Guantanamo Bay. All right. So now we're going to keep the broadcast going. Please hit the like button. I appreciate you guys. We're going to get into Judge Glanville recusal hearing and what he was talking about. So hold on one second. Okay. All right. So this is about, I hope it's a 20-minute clip. And we're going to break it down. We're going to listen to Judge Glanville. Now, this is after all of the escapades that has happened that we went through. And Tay being killed. Okay. Allegedly may having something to do with this YSL trial. I cannot verify it, but you know I'm out here in Atlanta. So my fees is a little bit different. Okay. So I get some things and this is word on the street. Now, what's scary to me is that I think this is going to escalate. And we also allegedly hear that other rappers are involved. Okay. This is ridiculous. Now, let's play this. So, as we go through the saga, we're going through a timeline. This is Judge Glanville recusal hearing. After the contempt, after all is said has been done, talking all the mess, saying nobody gonna see this. We just gonna keep the trial moving like a freight train. We deny your appeal. I'll make it a order. I deny your motion. I'll make it an order. All that hot mess. And when the Supreme Court knocked it back down to appellate court with that opinion in it, Judge Glanville is stuck behind his stuck between his legs right now. We all see the change of his tone. Let's listen together.
His immunity agreement, Mr. Copeland's, will be court 2.
It was just this very simple thing of like, okay, is my witness.
Nobody want to see that. Hold on.
Who was represented by Mr. Jonathan Melnick and advised of his rights and obligations. During the proceedings on Friday, June the 7th, which will be marked as Courts 3, the transcript of those proceedings, Mr. Copeland invoked his Fifth Amendment privilege and was held in contempt.
Many times, though, let's highlight that. He would told them that he was going to plead the Fifth many times. And I want to highlight this because when we get into the ex parte transcript, you're going to see that he had communication with the DA before that ex parte meeting several times and hinted to them that he would be pleading the Fifth.
And that will be Courts 4, Mr. Copeland's order of contempt. Mr. Melnick informed the court that he was not going to be in attendance of any further proceedings as he would be on leave effective 10 June of 2024. The court informed Mr. Melnick that his leave, or had discussions with him that his leave was not proper and that he needed to be in attendance on Monday, June the 10th of 2024 with Mr. Copeland.
This is a timeline. So Mr. Melnick and Ms. Bumpus are together with Woods, okay? Mr. Melnick is the gentleman who you don't see, but originally was in limbo to represent Woody because he represented Woody before. But in this particular hearing, Mr. Melnick was trying to pull himself out because of what was happening to Woody, and he knew he was going to be railroaded, and Mr. Melnick was allegedly going on leave. And this judge literally, through the ex parte, tried to say, I don't care, he's not going on leave. It does not matter. This trial is going to go on. He needs to be here. And then tried to push it on Ms. Bumpus. Okay, this is the clarity of this situation right here for you guys.
Mr. Melnick relayed that attorney Caleb Bumpus would be representing Mr. Copeland. On Monday, June the 10th, before court, Mr. Edward Chamberlain, the court's litigation manager, informed the court that the state wished to have an ex parte meeting with the court. No subject matter of the ex parte meeting was told. The entirety of the ex parte hearing held on the 10th of June of 2024 was taken down by Ms. Christina Weaver, the court's official court reporter. This ex parte hearing was held in chambers starting at 9:10 a.m. Present along with the court were Ms. Caleb Bumpus, attorney or ADA Ms. Adrian Love. Also present were the DA's investigators, Mr. Long and Mr. Hamilton. The ex parte hearing stood in recess from 9:34 to 10:03 a.m. to await Mr. Copeland's arrival. The ex parte hearing resumed with Mr. Copeland present at 10:03 a.m. Also present were attorney Bumpus, Ms. Hilton, the DA's investigators Long and Hamilton, the court and security personnel, deputies Houston, McPherson, Brown, Sergeant Brown, and Sergeant Hall.
They named, you see how many people were in that room with Woody? And those may have been the same people who were ice grilling him outside over the last couple of days that still in the other attorneys noticed.
The ex parte hearing stood in recess to allow Mr. Copeland to have a private conversation with attorney Bumpus from 10:17 a.m. to 11:28 a.m.
I chose St. George's.
And while this is going on, I want to highlight this because I did not play that clip. I want you to go to the attorney's page to watch it. Basically, Ms. Bumpus says, I don't remember talking to him this long. She says she don't remember having this long of a conversation with Woody, because for an hour, you should remember the conversation because you should be giving him some legal advice. So I'm bringing that up because this is the things that the judge is putting on the record. If we're able to see the other hearing in real time, that would be amazing because we're going to see the contradiction between his statements and Ms. Bumpus' statements. And that's why I was a little skeptical with Ms. Bumpus coming out talking so much because she has to face this man. As you see, Mr. Still said specifically, you are now a witness. You in the state are now a witness, and you have to recuse yourself. You have to let another judge listen to this. So they're all going to be in a hearing together, and he's not going to be in that seat. All right.
The ex parte hearing resumed at 11:28 a.m. The ex parte hearing concluded at 11:31 a.m.
Oh my goodness.
The court arrived in courtroom 1C at 11:49. The transcript of those proceedings, starting as of 11:49, or when the court presumed that held the proceedings on 10 June in courtroom 1C 2024, that will be marked as courts 5. The proceeding in 1C commenced on the record at 11:52 a.m.
So everything that he did not put on the record on that day, that's what he's trying to put on now. And to me, that's telling me that he knows he's in deep doo-doo. I think he knows he's in deep doo-doo.
A lunch recess was had at 12:51 p.m. The parties returned from lunch, and Mr. Steele informed the court that he had a motion, and that was at 1:46 p.m. In asking then Mr. Steele later that afternoon was held in contempt. However, he was allowed to continue representation of Mr. Williams. The court, in asking Mr. Steele questions of how he received the information that he proffered in open court, was only concerned about the integrity and security of the conversations that were had in chambers, not whether those conversations were the subject of proper ex parte conversations or the sum and substance of what was told to him at that time.
So he's highlighting that Steele wanted to know why he was not told about the ex parte, not the subject matter totally at that time. That's what he's saying, because you heard that day the judge was basically like, tell me who told you, tell me who told you, basically like, you just stop talking, you know too much. And that was his concern. So just listen to what he's putting on the record.
Jurors Jurors entered the courtroom to resume Mr. Copeland's testimony at 3:39 p.m. The jurors were excused and exited the courtroom at 5:56 p.m. Mr. Copeland was excused and exited the courtroom at 5:58 p.m. The court asked Mr. Steele again whether he received ex parte information, and that would be at 5:59 p.m.
So basically, he's highlighting that he continued the trial while Attorney Steele was held in contempt. They let Steele come back out because at the end of the day, Young Thug was like, he said that was his primary lawyer and he can't continue the trial, and you're interfering with his right to defend himself. And that's why Steele was able to come back out that day. And he allegedly gave Steele an extension to 5:30 that day to tell me who told you, or you're going to be held in contempt. He tried so many different measures, to try to get him to purge himself, but still stood strong. And at the end, still came back like, listen, two things. Well, one thing, can I be in the cell with my defendant, with my client? He said, because I have to come to work on Monday and I need to be prepared. That's even showing you a heightened level of case interference by even trying to throw this man in jail on the weekend, knowing that they have to prepare for everything, every motion they want to move forward to, any type of evidence that came in. They have to review all the videos, find the issues, put motions in to get these things taken out. This happened. This is a 24-hour job as a lawyer. That's why I do have respect for honorable lawyers. This shit ain't no joke. So Steele was going to try to get his paperwork in that jail, funky ass jail, mess around and had an asthma attack and did what he do. Shout out to Steele again. You know I love him. Let's play this.
Mr. Steele's counsel, Ms. Ashley Merchant, and Mr. Alex Susor entered the courtroom. Mr. Steele was held in criminal contempt. That order of that contempt will be marked as Court 6, and the proceedings concluded at 7:41 p.m.
You know why I smile so big, right? Because they said Ashley Merchant. Let's put her on the screen if you don't know who she is. Is another honorable lawyer. Came in there hot. You know, if I love them, they're going to get represented on here, baby. Hey, go Ashley. Go Ashley. All right, let's move forward.
The court further takes judicial notice of the following statements proffered by Attorney Steele, Brian Steele, in open court upon information and belief stated to the court, which are still unknown. There are 6 assertions that Mr. Steele proffered in front of the court. Those are contained within the transcript of Courts 5, the proceedings that are held on the 10th of June of 2024 in courtroom 1. and see which the court's already said will be
We
part
have
of this
that.
order.
We have that. We're going to read that next, okay? We're going to read that together.
The first assertion.
We're going to read all of Still's assertion. You hear what he says, but we're going to read Still's word for word, okay?
And the transcript bears out exactly what Mr. Steele said. So the court is paraphrasing the six assertions that Mr. Steele made. They're more aptly and more eloquently put in the record. The first one involves his concern that
I'm Millie, a content creator, coach, and business owner. If I had to start.
Stop it. You got commercials on yours.
Supposedly in chambers, dishonorable court reporter, court at times, district attorney or district attorneys before the DA's office, as well as investigators, sheriff, and deputies. Mr. Copeland and his counsel met together. None of the defense team, to his knowledge, were present. Second assertion he makes is that Mr. Copeland intended to plead the Fifth Amendment.
Yep, he did.
Third assertion is that Mr. Copeland, as a party, was sworn, and Mr. Steele asserted that this particular conversation was, in fact, a critical stage, and that the defendants had the right to be present. The fifth group of assertions involved Mr. Copeland not going to testify. The fifth group of assertions involved what Ms. Attorney Hilton claimed or said to the witness, to include the court, involving allegations of coercion and witness intimidation, and that his counsel had the right to be present. And the sixth assertion that was made in open court was that Mr. Copeland admitted to killing Donovan Thomas. At some point after Mr. Steele was held in contempt by this court in the afternoon of June the 10th, it was brought to the court's attention, not at the court's request, by security personnel that video footage of what occurred outside courtroom 1C shows the interactions between Ms. Bumpus, Mr. Steele, Mr. Adams, and Mr. Sharp.
Now we're going to stop right here because I want to highlight, we went into this yesterday, that allegedly Ms. Bumpus said that she was not the first person to talk to them about this. She was the second. And by the time she brought it to their attention, or when she talked to them, she gave them more information, filling them in, as per the interview on the attorney. Now that was caught on camera. And at the time, all that chaos was going on that day. The judge didn't see all that, didn't know, but he went hunting. He had to go hunting to see what went on all around that court to find that actual clip. That's how much he a monster.
The court in no way sought to investigate any facts.
That's a lie. You see what I just said? He said the court, he's trying to put on record that I did not try to investigate any facts or anything. And I just told you, yes, he did. So how did he get that tape that he's putting on the record? Somebody just gave it to him?
Involving this footage.
And I'm just saying he's going to use that to hold that against Ms. Bumpus. I just have this feeling, because even though it was not secret, he's going to try to find some ethical issue in what Ms. Bumpus did. The prosecutor is disgusting. And that's what they're going to do. I bet you. That's why if anybody knows Ms. Bumpus, tell her to be quiet and get herself prepared. She needs to get on Still team, take some classes that Still took, ask Still be her mentor, and get it in, because I think that Judge Glanville is going to try to throw her under the bus for actually doing this and thinking that she set this off by telling. That's just my opinion.
And only considered it for the security and timeline of events that occurred on June the 10th of 2024. Also, in no way did the court consider any of this footage in holding Mr. Steele in contempt. And as I said, mentioned it only for the purposes of considering the security and breach of information that occurred within the court's chambers.
So he's putting his defense in this record right now for the next court to review, because this is his order he's making, okay? And he's saying, I just basically got this tape or whatever that he just put on the record for security issues and security breaches. Listen in detail. He's setting up his defense. Miss Bumpus, you gotta listen. I know you're listening. You better get ready to counteract this.
Not for the whether or not that was truthful or not.
It's that time of year again. It's
we watching somebody video in live time, and I will put this video at the bottom so y'all be able to see. I can't download all of this stuff.
Mr. Steele makes
shout out. This is actually this is the Paralegal Institute of Washington. Shout out to him. I think he's actually going live too. It's his first time going live, so shout out to him. I'm using just the bits of his clip, and these clips are actually public clips, but he got the right parts. So shout out to him.
Further made three assertions on the 10th of June of 2024. One, he asserted that this was, on behalf of Mr. Williams and similar situated individuals, that this was the court held an improper ex parte meeting. Secondly, that Mr. Copeland was a sworn witness, and this was a critical stage. And no, Mr. Copeland was a sworn witness. And third, that he argued that this was a critical stage and that he and the others needed to be present at that point in time to pursue the Sixth Amendment rights of the defendants in this case. As to Mr. Steele's first assertion of whether or not the court held an improper ex parte meeting or hearing, the court is guided by Judicial Code of Conduct 2.9, which I'll take judicial notice of, which in pertinent part, where circumstances require ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with the substantive matters or issues, provided that the judge reasonably believes that no party will gain any procedural, substantive, or tactical advantage as a result of the ex parte communication.
Let's stop. What the judge is doing is reading the law. And as he read the law, I want you guys to listen how everything he did is completely opposite. Okay. So one of the requirements that he stated first of ex parte law is that the defendant and the prosecutors and all parties to the case must be aware of it. So there is no gain advantage between any parties. Period. It's not except on this, except on that, or amendment. You got to listen. If there's amendments and things and they say except when this, that, and the third, then that's when it's an exception to that. So just listen.
And the judge makes provisions promptly to notify all parties of the substance of the ex parte communication and gives parties an opportunity to respond. And in this particular circumstance, the transcript of these proceedings was just prepared and is final by my official court reporter, Ms. Weaver, and all counsel will be, as I said, given an opportunity to, as soon as the court finishes entering this order, it will be e-filed, so everyone will have a chance to take a look at it and use it as they see fit. In this particular, and then the last part of 2.9 before the court goes on, if involves in pertinent part, if a judge inadvertently receives unauthorized ex parte communication bearing upon the substance of the matter, the judge shall make provision promptly to notify all parties of the substance of the communication, provide the parties with a reasonable opportunity to respond. And as I mentioned earlier, I'm going to release the entirety of the transcript to you all to use as you see fit and before any other further examination of Mr. Copeland.
All right, so you see here, hold on. Let me just pause it. All of that hot sauce that he was popping, all of that hot sauce is totally different now. Before he said, we're going to be giving you bits and pieces of what we feel you should see on the ex parte communication. He was going in the last few days about that and what he was going to do. And now you see, he's going to release the whole transcripts, and that's what we have for you. Now, I'm going to get a little distracted, y'all guys. Don't get mad at me. You see the court reporter, Valerie? I found who the court reporter looks like. It's two characters, but this is the one that the court reporter looked like. She beautiful, though. I'm not being mean, but we're going to have a little moment here, Valerie. You already know. You was like, what is wrong with this court reporter? Don't she look like him? Don't she look like Beavis and Butthead? Am I tripping? Am I tripping? Now, you see, put this on the screen, and then we're going to put the court reporter there. All right. And it's one more person. I'm cracking on the court reporter right now. I do apologize. Let's put her back on the screen. Let's get the proceedings back going. Valerie, tell me, am I off? The court reporter, tell me, am I off? Remember you was asking about this lady. Doesn't she look like him? Don't she look like him? All right, let me cut it out with my crazy self. Sometimes I get sidetracked. I'm like, look at this lady. Look at this lady. But she's amazing. But what I will say with the ex parte transcripts, there are some things that's missing. There's some dash. There's some I know, you know, detail. I'm like, either these people can't speak or the court reporter messed up on some shit. So I'm just going to keep it real, okay? If his mouth was turned upside down, yes, when he closed his mouth, it's kind of like that. But I'm going to show you the other character too once I find it. Okay, it's a Nickelodeon character. We will get to it. Okay, all right, let's play this.
Address the issue of the emergency nature of this particular hearing or this particular conference in front of the court. Is that this involves the state's concern as to what Mr. Copeland was in fact told by his counsel, Mr. Melnick, and his understanding of the immunity agreement pursuant to 24-5 507.
Now that's talking about competency and his understanding about pleading the fifth. Okay.
And that the conversations that were had in the transcript will bear out that no tactical or other advantage or any testimony that was stated during that particular hearing would be anything other than the court and or the state communicating, along with Ms. Bumpus, his lawyer, who was there the entire time, his witness's understanding of his immunity agreement. In consideration of this emergency nature, the court is taking into account a couple of cases I'll cite for the record. One of them is United States versus Adams, and that's 785 F. 2nd 917, decided in March the 31st of 1986. In pertinent part, presence of the accused. Although an ex parte conference to discuss threats against the witness is proper, district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. Presence of the accused. Ex parte conference between judge, prosecutor, and government witness to discuss refusal of witness to testify because of his fear of reprisal was not improper, where substance of the inculpatory testimony was never discussed and the entire conference was transcribed.
Sorry, I knew I was mute. So basically, he said that at no point was there any communication about his testimony inside of the case. And there is a little section inside of that ex parte that the Miss Hilton, and I didn't know her name yesterday. I ain't gonna forget today. That's Miss Load 'em up questions, bust 'em up shots. Yo, she was driving Woody crazy. Her and Woody was going at it. I wish I had the clip too, just getting sidetracked. Did y'all see the clip where Woody basically told her to get away from him? Because he tried to make it seem like she stink. and she went running because he started coughing, and she went running back, and he was like, wait, get away from me. I'm gonna try to find that clip. Him and her were going through it. Miss Hilton, okay? So let's listen, as he mentioned, that it was no time that basically any testimony was talked about. Okay. And ex parte meetings, from my knowledge, is supposed to address outside issues that can affect the court, not the court matter. Issues such as, I can't be here because I have a death in the family, I have cancer, I have this treatment, or I fear for my life. I got a threatening letter, something else. But everyone needs to know about this ex parte. And usually ex parte meetings are initiated by the person, the witness, not actually the prosecutors or the judge. Okay. Just to give you a little bit more insight into ex parte. Okay. We almost done with this clip.
And in Adams, the appellants contended the ex parte conference was improper and it violated their due process right to a fundamentally fair trial. We agree with appellants that ex parte conferences should occur, but rarely, especially in criminal cases. This does not mean, however, that such conferences are unconstitutional. Indeed, some situations, the trial judge may find an ex parte conference necessary. Cite.
I've helped non-tech people get into tech and land multiple six-figure cybersecurity jobs. And
La Chapelle, and that's LACHAPPELL versus Moran at 699 F. 2nd 560. It's a First Circuit case from 1983, where the court cites, in the exercise of the court's residual power to ensure a just trial, protect jurors and witnesses, a judge may, in rare circumstances, feel it necessary to confer with a juror or witness on the record, but outside the presence of others, including the defendant. One such conference may be where a juror or witness, having been threatened, wish to speak with a judge privately about a threat.
So he's giving examples in his order. He's filling all of this up with fluffer, y'all. Just fluffer. For real. But listen, he's reading the law.
Witness may not feel free to discuss any threats in presence of the defendant or even counsel for the defendant. We agree that the First Circuit, that an ex parte conference is appropriate in that situation. They see United States versus Arroyo, and it's ANGULA. It's at 580 F. 2nd 1137, pinpoint 1142, and 1141, 1142, Second Circuit case. Exclusion of certain defendants and counsel from in-camera proceedings permissible in multiple defendant trial, where certain defendants had cooperated with government and received death threats. And they've got a citation for that being 439 U.S. 913. Although an ex parte conference discussed threats against witnesses proper, the district court must ensure that the conference is carefully conducted so no rights of the defendant are threatened. In this case, the court followed procedures to ensure the conference was fair. First, at no time was the substance of Pooley's inculpatory testimony discussed. And second, the entire conference was transcribed. And that's United States versus Watchmaker at 761 F. 2nd 1149, 1985. Ex parte conference with frightened juror properly were transcribed and the judge's comments carefully framed. This court goes on to say in Adams, two aspects of this conference, however, are disturbing. First, when the prosecutor began to impress upon the witness the distinction between being paid for testimony and afforded protection, the trial.
He's giving more examples. And the reason why I'm shaking my head, because every example he gives literally is heightening more of the fact that he wasn't supposed to do what he did and that it's supposed to be transparent. He's not giving any law actually to support what he did. He's giving law to the defense. I don't know what he's doing here. It doesn't make sense. Any person who researched law knows something's wrong with him.
Court should have called the conference to a close.
And this is what he said. Okay, just listen. I was talking, but we're going to listen to that again. If anything that is critical that can cause any issues to the court case, i.e. something that has to be put out on Front Street in front of and put on the record within the trial, the judge is supposed to stop the ex parte meeting and bring it into the front. And this is what he's talking about.
Witness the distinction between being paid for testimony and afforded protection. The trial court should have called the conference to a close. The portion of the record quoted above indicates an attempt by the prosecutor to coach the witness on how to answer questions about inducements from his testimony. The court had already learned all it needed concerning the witness's fears and the prosecutor's plans for protection, there being no reason to participate in such coaching. Second problem occurred where Pooley took the stand. Defense counsel inquired about what inducements had been given for Pooley's testimony, and the prosecutor and Pooley both indicated the promise was the prosecutor would seek to enroll Pooley in witness protection program if he were in fear of his life. Neither related to the prosecutor's pledge to seek immediate protection for Pooley should it be necessary. The exchange occurred before the court, and the court should have made sure that the inducements made as in the ex parte conference were completely and precisely disclosed.
I'm gonna stop here. You see why I'm making my face? This hurts me because Judge Glanville couldn't have read this before he got there. Somebody had to write this up, trick the paper, switch it, because everything he's saying for the reasons to actually stop an ex parte and the things that he was supposed to do when Woody felt like his life was in danger, as I mentioned to you yesterday. Witness protection, start moving forward with other matters, especially when someone is in an ex parte meeting, disclosing to both sides and within what he's talking about, according to the law, and they were supposed to move forward and stop the proceedings and do whatever they need to do to protect the witness. Oh my God. He also talks about coasting or coercion between any side and the witness. And you're going to hear specifically when we read the ex parte that Miss Hilton and the judge was coasting him, was kind of pushing him into, hey, don't plead the fifth. You're going to go to jail. You're going to go to jail. You're going to go to jail. It's Father's Day. It's this. Somebody's birthday. They was using everything they can to stop Woody for pleading the fifth again when he went to court after they held him. I'm just giving you a heads up. This is so funny to me. I'm like, no way the judge wrote this and read this shit. He gave everything to the other side. Welcome to Urban Politics, where you're here with Grace Levi, your hood legal nursing consultant translator. This is what I do. And I be amused in the background like, yo, did this person do this? Oh my God. Judge Glanville is setting himself up to be recused. He gave them everything. And I'm looking at this, keep going. I can't believe it.
Similarly, in this matter,
crazy. I'm sorry.
To me is basically freedom.
I don't. What the hell wrong with him? He lost his mind. He ain't not. Now he went from being. Hey, hold on. He went from being extreme, right, to extreme until now telling on himself and giving the defense something to work with. What is wrong with this? This is the post-traumatic stress syndrome kicking in. Oh.
The only thing discussed between the state counsel for Mr. Copeland and this court with the understanding of his immunity agreement. There were no other testimonial statements made by in terms of what Mr. Copeland planned to testify to that were induced or sought by the court. And the transcript in its totality will bear that out. You can have a look at that. The court's also considered Bruner versus the state. That's 302 Georgia at 6, and this relates to the right to be present and what is defined as a critical stage and under the Sixth Amendment.
I'm just trying to push this a little faster. We're almost done with this clip.
Bruner contends that he was denied the right under the Georgia Constitution to be present at certain critical stages of his trial proceedings. Embodied within the constitutional right of the courts to a criminal defendant's right to be present, see and hear all the proceedings which were had against him on trial before the court. Ward versus the state, 288 Georgia, 41, pinpoint 645. Violations of this due process right are presumed prejudicial, absent a waiver by defendant requiring a trial. However, there were no violation of Bruner's right to be present. The right to be present attaches to any stage of a criminal proceeding that is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure. And that's Huff versus the state, 274 Georgia, 110, pinpoint 111. Thus, a critical stage of a criminal proceeding is defined as one in which the defendant's rights may be lost, defense is waived, privilege is claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And in this particular case, the court is of the opinion, basing on the case law, that
and again, this he gives more to the defense, and he says that in any time he's supposed to stop the ex parte meeting if a witness was losing any rights, okay? If there was any situation that the witness was losing their rights, and it was, they set Woody up, okay? Through the transcript, you're gonna see, we're gonna highlight Woody talked to these DA several times before this. He asked them in different ways. Well, if I plead the fifth, do I got to do this? I'm going to be locked up. If I plead the fifth, I'm going to be locked up. Is this going to happen? He kept asking it in different ways at different times. And even just before they met. And I'm going to tell you, I felt like where they met at was dangerous. It was a signal to the people out there in the hood what was going on. When we get to that, I want to tell you. But even at that time they met, Woody was suggesting that he was going to plead the fifth. It was what it was. And then he got there on Friday and they present him with immunity and say, hey, we present you immunity. Whatever you say is not going to go against you, this, that, and the third. But you got to understand, this is on a state level. The immunity they're giving him is on a state level. It's not on a federal level. Okay? So if Woody was to testify to anything, two factors. It's not protection on a federal level. If Woody was to testify anything that will be able to be substantiated with evidence, there is a possibility that the state could pick up charges. And that will be on them if they choose to. And that was what they were asking in the ex parte meeting too. And they were like, well, we won't do that. They kept saying, we won't do that. We just want you to tell the truth. So I wanted to break that down, how Woody rights was actually taken away through the ex parte, because I'm giving y'all more of the ex parte, just leaking it to you guys. And he did not stop the proceeding. Judge Glanville gave his defense, everything. And I think he wants to retire. That's my opinion. He got to want to retire right now. The game is over. It is. The game is over.
That this was a proper ex parte meeting pursuant to Rule 2.9, as well as the no party gained any tactical advantage, and that
Cali Express touts itself as the world's first fully autonomous restaurant to the road.
The proceedings as a whole are released to in the terms of the transcript. So what was said can readily be seen and utilized by the defendants. Okay, and the court lastly took into consideration Talton versus the state. That's 368 Georgia Appeals at 313, and that involves a Sixth Amendment critical stage definition that was decided June the 21st of 2023. And in pertinent part, in many instances, remand will be necessary when the right to be present claim under the Georgia Constitution is raised for the first time on appeal from criminal conviction. So Mr. Seals raised this at the appropriate time, and the court is in fact considering it. And the Georgia Constitution guarantees criminal defendant to be present, see, and hear all proceedings in which are against him on trial before the court. Criminal defendant's right to be present under the Georgia Constitution attaches to any stage of the criminal proceeding, which is critical to its outcome if the defendant's presence would contribute to the fairness of the procedure, but the right does not extend to situations where a defendant's presence would be useless or benefit but shadow. And under the Georgia Constitution, defendant who is represented by counsel need not be present for portions of the trial that involve questions of law and consist of essentially legal argument about which the defendant presumably has no knowledge.
That's why it should be the lawyer there with the witness, because if there's legal genre that's being taught, that's why they were trying to make Miss Bumpus Woody's lawyer. And Miss Bumpus like, I'm fired. I don't want to have nothing to do with this. That ex parte, he needed representation there. They were pushing this to work the way they wanted it to work.
It is well settled under the Georgia Constitution, guarantees a criminal defendant the right to be present and see here all the proceedings which are had against him or trial before the court. It's Prickett versus the state, 314 Georgia, 435 at 441 pinpoint. This right attaches to any stage of the criminal proceeding that is critical to the outcome of if the defendant's presence would be contribute to the fairness of the procedure. But the right does not extend to situations where the defendant's presence would be useless or benefit or shadow.
All right, we're going to stop right there. All right, so we listened to a lot of it. You hear his tone. What I'm going to do is just read a 2-page excerpt of Glanville actual first order of contempt. You hear Glanville's voice and how he's talking now and how calm, cool, collective he is, and basically how he set his own self up, telling on himself. That's why I like this, and I hope you guys are learning. That's why we're taking our time and going through this, because you can hear the bleeding out of Glanville and how he's going to lose his job, possibly. Now, what I want to highlight just before we get into his hot mess, I want y'all to understand the Sixth Amendment real quick, okay? Some of the aspects of the Sixth Amendment and what they were talking about, and that's the right to a fair trial, okay? So the Sixth Amendment has a few parts to it, and that is rights to secure a speedy trial, a public trial, an impartial trial, impartiality, meaning that you're not guilty just because, okay? And that's some of Steele's arguments many a time. To ventures of juries, to be able to select juries, you and them to go back and forth and say, hey, this one in, this one out. A fair sentencing, notice of the accusations so they can get prepared for their defense. And that's why notice of all proceedings, the right and ability for confrontation for you, the person being charged, to actually go against the person who's accusing you, i.e., this is Andrew Holmes' right under the Sixth Amendment for confrontation. And what I mean is that if they bring proceedings to him, he should have the right to cross-examine the witness or the person coming against him. And if a man is honorable and telling the truth, the right to confrontation is one of the best parts of waking up in a case under the Constitution to stand up for yourself. I just had to highlight that so we can put that in perspective of, you know, applying law to the situations we're talking about. The compulsory process, basically the administrative process, needs to be favorable and just. You know, they can't just be running through things like Glanville was doing, as far as when he didn't put the first order in and just basically say, motion denied. Nope, you can't recuse me. Da, 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 da. That's what he did not do. He directly went against the compulsory process. Everybody has the right to assistance to counsel. That's why they were trying to force Woody to have Miss Bumpus in the room with him, trying to force Mr. McCallum to be his lawyer. Okay. Also have the rights to self-representation, lastly. And that is an example of what Jedediah did when he was in court against BB. Okay. And that's why the judge respected the way Jedediah actually stood up for himself and represented himself, because you as the person can stand up for yourself pro se. All right. So I just wanted to throw that little Sixth Amendment teaching to you. Apply it to your life. Now, let's listen to this, all this hot mess that Glanville was talking when he was saying, still, you're going to jail. No matter what you say, you better tell who told you that. All right. That was all the hot sauce that man was talking that day. So let's just read this two-page filing. of order of contempt and incarceration for Brian Steele. This is on 6/10, the day that they keep referring. During the proceeding in this above style case on the afternoon of June 10th, 2024, one of the two representatives for defendant Jeffrey Williams, Brian Steele, took the podium and stated that the court had been informed of an ex parte communication which took place in the court's chambers that morning. The only parties present for the ex parte meeting were the court officers, court reporter, representatives of the state witness, Mr. Keith Copeland, and counsel for Copeland. In addition, what he missed out in this order was the 6 police and sheriff deputies that was there and the 2 detectives that was there that you will hear Ms. Bumpus verify in her interview on the attorney page. There were like 12 or 13 of them in there. Okay, so he left that out of his order. In addition, the court's serious concern, and this is Glanville order, serious concern with how this information wasn't properly disclosed to the defense counsel. Mr. Steele was made several claims regarding the sum and substance of the communication that the court found troubling. The court has told Mr. Steele multiple times that he needs to tell the court how he came into this information. The court has explicitly warned Mr. Steele that he has faced contempt charges in court should he not comply. The court finds Mr. Steele has repeatedly refused to follow the court's order. Every court has the power to compel obedience to its order and to control the conduct of the person conducted within the judicial process. He controls, you be obedient, and that is the law that he chose. Okay? Not referencing anything about ex parte meetings, his right to do so, the blah, blah, blah. Now, one who disobeys an order or command of the court may be found in criminal contempt. Violating a court order, the order should inform him in defiant terms as to the duties where imposed upon him, and command must therefore be expressed rather than implied. So we're going to tell you that I'm going to lock your ass up. It ain't going to be just expressed. It's going to be implied. According to its honorable order, it is hereby ordered that pursuant to the court authority under OCGA 15-1-3, the court holds Mr. Steele in direct criminal contempt for failure to comply with this order. And the order is, you tell me what I say because you in my court. I don't care. It is further ordered that Mr. Steele shall be taken into custody of the Fulton County Sheriff and incarcerated at Fulton County Jail for no more than 20 days for this contempt. With those 20 days consisting of every weekend for the next 10 weeks. That is literally 2.5 months. Mr. Steele is to report to the Fulton County Jail, Rice Street, Atlanta, Georgia, at 7 p.m. on Friday. And we will release at 7 p.m. on Sunday, literally taking up his whole weekend, putting him in that hellhole of a jail. That was the hot sauce that the judge was speaking before it got kicked down from the Supreme Court and that opinion come down to with it. Does it make sense? All right. So now we're going to get a little bit into, do y'all want to hear motions to disqualify and recuse the judge? I do have that document that was filed 7 days later by Mr. Steele. And we could get into it just a little bit because he talks about some of the things that was with Mr. Steele concerned. And we could just highlight some of those, what Mr. Steele has to say. Okay. I'm gonna bring it to you. Let's get to the documents. So you get a 3-for-1 today. You get 3 different readings today. You like me better? What you're doing? This thing started moving. So Miss Valerie, it's better for me to read it or to get that voice on there. I'm just gonna read it because I got more energy today. Okay. So let's get to this one. This is actually the motion to disqualify, recuse Judge Glanville from all further dealings in the above referred case. Motion for mistrial, which was also go at by the improper conduct committed in ascertained by the court and prosecution. Let's go. Let's see what Mr. Steele got to say. We're going to try to run through this a little bit fast. On Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with the prosecution, engaged in an unlawful, improper ex parte meeting, among others, a sworn witness, Keith Copeland, for whom the order was used, immunity had been issued on Friday, the 7th, 2024. So that day when he showed up on Friday, they gave him that. No notice of the ex parte meeting was provided to the attorney for any of the criminal accusations in the case. In fact, the accusation in the accused and their counsel were in the dark that the Star Chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, 2024, asserting that the Fifth Amendment privilege in an open court in front of the jury and was held in contempt and similarly incarcerated until such time as he agreed to testify pursuant to the grant of immunity. So this is what he's highlighting. And this is what I told you. They literally forced him to testify, to say something by, oh, I'm going to help you. We're going to grant you immunity. And that was his new stance. And that's basically put him in jeopardy to be locked up 2 ways, through pleading the fifth and through perjury. The prosecutors are monsters. Miss Ain't Love, they know what the hell they doing, okay? So Judge Glanville and the prosecutors essentially admitted by silence and by some statement on open court that the ex parte meeting occurred on the morning of June 10th, only after undersigned counsel revealed based upon information and belief that this impressionable meeting occurred. Now, this could have been Mr. Malikan. I'm saying his name wrong. It could have been him, okay? Who was the first person to tell. We still don't know. We'll find out at that hearing. So at the earliest opportunity on the afternoon of June 10th, the court was informed based upon information and belief that the ex parte meeting with the sworn witness Keith Copeland and the prosecutors occurred earlier that day. That the witness had made factual admissions and statements were made to the witness by the court and the prosecutor acting in coercion. About the amount of time Mr. Copeland could be held in custody. The court denied the undersigned counsel request for the transcript in the ex parte meeting and denied timely motions for mistrial based upon the improper and illegal ex parte meeting, which violated Williams' a constitution and statutory right, including the right to due process, a fair trial, a fair tribunal, ethical procedures, and the right to be present at every critical stage of the proceeding. So he's talking about the rights of Jeffrey Williams being taken away because he didn't know that this was going on. Okay. Uniform Superior Court Rule 4.1 Georgia Code Judicial Conduct 2.9 rules govern ex parte communication. So this is what they go into, what we talk about ex parte communication and what it's supposed to be. Generally prohibits ex parte communications. Under this, he's highlighting a section. Generally prohibits ex parte communication except as authorized by the law or by rules. Judge shall neither initiate nor consider ex parte communication by interest parties or their attorney consider a pending or impending procedure. So 2 things: the judge shouldn't initiate it. As I told you, the witness is supposed to initiate it, and it should not have nothing to do with in consideration of the rulings, the judge's ruling. Okay, like for instance, somebody's life is on the line. That has nothing to do with the case of the judge's ruling. Okay, just to give you that's kind of like a third level connection. And the judge even talked about that. So it made me mad because the judge, I think he changed his tone, honestly, because he knows somebody got killed. And this was something in the ex parte that was kind of brought up. He brought it up. That basically I will read it to you. He brought it up in a way. So ex parte hearings are only authorized in the case that extraordinary matters such as temporary restraining orders or temporary injunctions and other judicial hearings. Both parties should be notified if the hearing with the opportunity to attend and voice any objections that may be properly registered. So he put the law, he put the case up there. Now, the court violated USCR 41 in the Georgia Code of Judicial Contempt 2.9. The court has joined the prosecution team and is based against Williams and favorable to the prosecution as objective determination on June 10th, as well as through the proceedings of the case. Because they've been saying it's like, look, you literally work with her. Like, this is bias. This is bias. We're watching it, and we've been saying it too, and we all don't know law. People were like, listen, this ain't right. This is crazy. So the trial court rejects undersigned counsel's subjective request for information about the unlawful ex parte, and the court denies undersigned counsel motion for a mistrial. So that's what you heard before in our opening, where he was like, nope, you ain't getting this. You're getting parts of this, and it's not going to be a mistrial. Moving forward, so the court stunningly demands to know how undesigned counsel came into the possession of the information about the ex parte meeting. The prosecutor stunningly sat mute and permitted this injustice to occur and for the court to attempt to intimidate the counsel. Later, Love and lawyer currently employed with the Fulton County District Attorney argued that ex parte hearings with witness Copeland was ethical, just and proper. The other prosecutors still remain mute. And we're talking about Miss Hilton sitting there and shit like, Undecided counsel declined to join the authentic in ignoring rules and ethical provisions and denied to provide information requested by the court. Relying on the state bar rules of professional conduct 1.6, which states this. So they talked about the professional bar rules that pertains to that of gaining information. Let's move on. The court ignored the ethical rules relied upon and continued to demand undesigned counsel to reveal the source of the information. Like, listen, I don't care. Who told you? Who told you? Claiming the way that the undesigned counsel obtained the information was somehow unlawful and basically accused undesigned counsel of recording of the potential acquiring of the information. He said, yeah, either you were in there, you had a recording, he was blaming it on Still too. In response to this, and that put Still license on the line. Okay, that put Mr. Still's license on the line. Now let's continue. The court is so biased against undesigned counsel. He like not only against my witness, the counsel, and Mr. Williams. The court ignored all law and pursued contempt penalties to attempt to intimidate undesigned counsel to violate the law and the actors in the order to continue to help the prosecution convict Mr. Williams. Okay, now this is the one that was sent up to the Supreme Court, what we're reading. Okay, the court issued a written order of contempt and incarceration for Brian Still, imposed a maximum sentence of 20 days, what we just read to you. The Supreme Court of the Georgia has granted writ of I'm saying it wrong. I'm going to cert, a writ of cert. I'm just going to say it, the breaking down. The writ of cert to address the appeal of the contempt order and has granted undesigned counsel to supersede the bond. So basically, the Superior Court took it so Mr. Still wouldn't go to jail real quick. And then they threw it down so it could be handled in the court. That's why the Superior Court pulled it, because there was no telling when the appellate court would have pulled it and who would have pulled it because of the situation involving Fulton County and its biasness. Okay, the court violated the law by failing its duty to recuse. Hold on a second. To recuse pending over the contempt charge. So at this point, he's like, just back up. Let's stop this trial. Let's see. This is what we're putting up. Let's see about the contempt charge. And you saw what happened. The judge kept going from 3 to 5 o'clock, still asking witty questions that day. In such proceedings where the announcement of punishment is delayed, where the continuous conduct for directed towards the judge, and where the judge reacted to the conduct in such a manner as to become involved in a controversy. The judge may give the attorney notice of specific charge, but the hearing included the attorney opportunity to hear must be conducted by another judge. So he basically said that the judge just looked at what he was saying and threw it out and didn't follow the law. Okay. And then according to 274 Georgia, in Schoolcraft case, this is where he was supposed to give it to another judge, okay, to see that motion that they put in for recusal. Okay. So then here, the court involved himself in the proceeding by joining the prosecution team and conducting an ex parte meeting that violated Mr. Williams' right. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of the issue. The court then compounded its abuse of power by proceeding over the very contempt hearing where its own rule violation prompted the controversy. And that's what he was saying. The judge said, "Nah, I hear it. Nope, let's go. Let's move on." So the court should have recused and allowed the contempt proceeding to be held by a separate court. Furthering, the prosecution sat there mute and permitted the court to attempt to interrogate and intimidate another member of the bar who reportedly violated the law, as also promoted the court wrongful conduct by asserting the ex parte meeting was improper. And that was, I believe that was still partner. And it was another lawyer that tried to bring that up. It was two more. And he was like, "Get out of here. I already know. Motion denied. Shut up. Sit down. You don't want problems." I didn't even show y'all that clip. This is what he was saying. You don't want problems. All right. And this was the judge. The court denied Mr. Williams and undersigned counsel their due process, right, as undersigned counsel has the right to adequate notice and to be heard and to call witness and to hear and to request the counsel for the entire of the contempt proceedings. And Williams had the right to learn of all the facts, circumstances, and the critical stages of the proceedings that occurred in his absence of the ex parte. So two things happen. This is when you have Miss Merchant coming, Miss Ashley Merchant, her role in there, where basically she told the judge, "You didn't have a hearing. You held him contempt. There was no pre-hearing. You did not give him a chance to get an attorney. We here for it." You remember that's what Miss Merchant was talking about. And this is how it's restated in the disqualification motion that's put together by Steele 7 days after what we just read. All right. So the court abuses authority by holding undersigned counsel in contempt by refusing to divulge privileged information for the protection of Williams. Constitutional rights and due process, right to a fair tribunal, right to a trial, right to the presence of effective counsel. And what amendment is that, y'all? The Sixth Amendment. Okay. Just to remember. This court refused to acknowledge the rights and the protections that was created under the Fair Tribunal based upon Mr. Williams and his counsel in favoritism of the prosecution. Motion to disqualify recusal Judge Glanville is timely filed in the Uniform Superior Court. That is one of the proceedings for that. The recording also reveals numerous instances during the trial when the judge behavior appears to be biased against Mr. Williams, counsel parties in favor of the state. Millhouse versus State. This was an example of it, some case law. Now, he goes on to say, I'm trying to move out of this abbreviation. The record reveals other instances too, when the trial court wrongly battered counsel in front of the jury. After the numerous such incident, Mr. Williams' counsel out of the jury presence moved from the trial judge recusal and sought a mistrial on grounds that the judge has showed a lack of objective, had displayed bias against Mr. Williams and his counsel. That was another time in December where we showed you yesterday that he was like, "Yo, you literally calling me out for no reason. All I'm trying to tell you that I want to hear something on this tape or to be addressed." And he was taking it to the left, telling me he wasn't prepared. And he said that in front of the jurors, but didn't want to correct it. So this is where still is showing the continuance of bias. And that is just one damn incident. Okay. The Code of Judicial Conduct provides the judges such qualifying themselves in the proceeding in which their impartiality might be reasonably questioned, including but not limited to the instance where the judge has personal bias, prejudice, concern a party or party's lawyer. And it showed all through it. Within the context of this required that words should mean shall. The same Supreme Court is mindful of the extraordinary pressure attached to criminal trials in this magnitude. So he's like, listen, words mean everything and reputation mean everything. And this pressure in this trial. And on one hand, defense counsel is obligated to vigorously defend his clients against all charges brought to the state. Likewise, prosecutors must effectively and ethically present the state case to the jury. You can't just go out there willy-nilly, and that's what's expected of the judge. And at the same time, and this is what he's going to add, that's what I know still, and at the same time, the trial judge is charged with ensuring that the rules of evidence procedures are followed and that the procedures are both orderly, ethical, and fair. When there's several instances came together in the courtroom during trial, disagreements between the bench and the bar are to be expected. The instance discussed above and in attached Exhibit B, so he gave some exhibits with this, joint affidavits, however, represents more than mere friction between the zealous counsel and the diligent jurist, okay? The judge conduct and discussed above and hearing create an impression that the honorability and the inclination of bias against William and his counsel and partiality towards the prosecution are therefore not in. Here, higher court needs not decide whether such bias and impartiality actually exists, because judges are ethically bound to disqualify themselves whenever there is an partiality might reasonably be questioned. Just might, not that it is questioned, might, including instance where the judge behavior could be indicated that he has personal bias or prejudice concerning a part of the party or lawyer. As explained, the trial judge in this case participated in ex parte communication with the prosecutor in which he assisted the case to influence a witness to testify against Mr. Williams. These actions raised reasonable questions concerning judge partiality and bias. Because the trial judge impartiality is reasonably questioned, it is error to deny Mr. Williams' motion for recusal, according to John versus State. Do you want me to keep reading this, guys, or y'all want me to get into the actual ex parte reading? I can keep going, but this is actually Still's motion for recusal. He's putting everything on a record. You already know what's been going on with the judge. Let me see if there's anything that you want me to keep going. Which one? Say yes. You want me to keep reading this or move on to the next one? Give me in the comments, okay? Until then, I'm just going to read a little bit more. Georgia courts has followed this demand for recusal when the judge become embroidered in controversy. You see how I said embroidered? That's my Jersey accent. All right, in controversy. Due to procedural requirement that he read the law, this is in Berger, also in Adams. We're not going to read that law to you right now. Second, due process require recusal of the judge when the judge takes a role in the process, the accusatory process, and that's what he did during the ex parte meeting. Okay, and this is found in another case law that he says Murchison, that he highlights here. He gives the excerpt from there. Importantly, a trial judge has the duty to recuse himself from the proceedings in which the judge impartially might reasonably questions, include instances where the judge has a personal bias or personal bias, prejudice concerning the party. We read that. Yes, finish that one first, then move on to conclusion. Okay, cool. So he restated that recusal is objectively required when the judge serves both as the accuser and the adjudicator in the case. So he's giving case law there, where he's like, hey, basically you're playing both roles. And that's William versus Pennsylvania. he goes in to say, in the case at the, okay, that's about the because I'm not going to talk about those cases because it'll throw you off, because those cases be remarkably different. But when we go into case law, if y'all ever want me to, I can explain how you can incorporate case law in a different case. Okay, but now this court has failed to follow the lawful path. Instead, the court has usefully become the prosecutor, judge, grand jury, bias, partial, potential sentencer, and thus must be removed from this case in tutu. Okay. On the motion to disqualify, it is the duty of the judge to pass only the legal sufficiency of the facts allegated, and to ask whether these facts support a charge or base the prejudice. So when he put that motion into recuse several times, the judge is not looking for basically to have everything as evidence. He's just looking for it to be structurized right, that it is some facts behind it, and that he that will make him move that motion forward. And the judge know that everything he put in the motion was fact findable. The ex parte meeting, the bullying, the intimidation, all of that, that's on its face facts. Okay. So the test is whether, assuming that the truth of the facts alleged in the attached affidavits is reasonable person will conclude bias exists on the part of the judge. And we see any reasonable person that's what makes the law. Law is based on what the reasonable person would assume. It can't be based on what you want it to be. It's what everyone in this area would assume. I.e., example, if you leave something down on the ground and you leave it for 2 days, according to the law, the most reasonable person would assume, according to the law, it's abandonment. But most reasonable persons would assume you abandoned it. You left it for 2 days. Now, if somebody picked that up and then you come back like, that's mine because they're using it, then that person may have a fight for abandonment, for you basically abandonment. Does that make sense? And that falls under the guise of any reasonable person, us being the citizens, would assume that this is thereof. That's how law should be based. Okay, does that make sense? And what we can see, every reasonable person who watched this damn trial, even the grandmas, grandpas, babies, like, what is going on here? What's wrong with this judge? Okay, so we're just going to read this last paragraph because this is a 27-page document. I'm not going to read it all because we got to get to the 50-page document, but I want to get through. I got through most of it. The court conducts raised a strong finding that he has become personally embroiled in the case. It is clear, even the casual observer, that the court involvement in the controversy requires that the court disqualify, recuse, remove from all further proceeding in the above referenced case. And another judge who will exercise the power to the judicial branch with a partiality, clarity, and fairness must be appointed to this case. Downey versus Palmer. Okay. Now, what we're going to do is stop right there, and we're going to keep things a little bit spicy, because now we're going to get a word from one of our other favorite lawyers that's going to bring us into the ex parte reading, okay? And we're going to hear from Lawyers for Workers again. He had an update 19 hours ago. New judge, a new motion concerning recusal in YSL RICO case. The YSL RICO trials involves rapper YSL thugs. Hit another twist for the week. Let's put it on the screen. Shout out to Lawyers for Workers. Please go to his Instagram page, okay? He was going to go on YouTube, but he just never did it. You know, like some people can't really get into YouTube. I think he tried it, but Instagram is his page, and I appreciate Lawyer for Workers, so check him out. All right, let's play this.
Update in the YSL case. A new judge has been assigned. Let's show you her picture. Judge Rachel Krause will be deciding 3 separate motions, each motion asking Judge Glanville to be removed from the case. Now, initially, Judge Glanville had rejected these motions, and then he said, wait a second, it's not right. I'm not the one who's supposed to decide these motions. It has to go to another judge. This new judge has ordered that the government has to respond to the motions by, get this, Monday, July 8th. So they'll be working over the July 4th holiday. Another very interesting development. One of the defendants has filed a motion asking the new judge, Judge Krause, to recuse herself. They cite case law from the state of Georgia, arguing that when one judge is deciding whether another judge can stay on, those two judges should not be from the same court. In this case, they're both Fulton County Superior Court judges. What the motion from the defendant is arguing is Judge Krause should recuse herself, and send this to a judge in another county, not Fulton County. And we'll see what happens. Definitely by Monday, you're going to get a response from the government. And sometime next week, hopefully we'll hear whether Judge Krause is going to decide this or whether she's going to step aside and send it to another county. Update in the YSL case.
You hear it. We're waiting to hear if another judge from another county is going to see this actual recusal hearing and continue down this escapade, and possibly we get another judge on this court when this happened to Glanville. Okay, what we're going to take is a few minutes intermission because we are two hours in. We have an hour and 15-minute read of the ex parte reading. Yes, you're going to be with Grace Levi for this 4th of July. But until then, we're going to put this on the screen because you know what's about to happen. What's about to happen to Glanville? Tell me what's about to happen to Judge Glanville. Let's put it on the screen.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job. I'm Martinez. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your J-O-B. You about to lose your job. Get this dance. You about to lose your job. Get this dance. You about to lose your job. Is this shit worth you losing your job? Cause you bought to. Cause you ain't got no reason.
Yeah, Jamaicans, true Israelites. We love to see the wake up in our place. Cause we, remember, it's not Jesus gonna come back, it's Yeshua. True Israelites, yard people.
and they shall fall by the edge of the sword, and shall be led away captive into all nations. And Jerusalem shall be trodden down of the Gentiles, until the times of the Gentiles be fulfilled.
Imagine if my small business blew up overnight and I woke up to some sales. Boost this video so people who like my products can find me.
Algorithm. Where you at, bitch? Because I'm tired of posting viral content and getting 2.5 likes. We finna fight, ho.
I ain't got no behavior. What's up? Thank you for making it through our interlude. That was another sponsor of this channel or someone that we support, H to N. We're going to put their Instagram page under. Everything is all good with guerrilla warfare. Only the chosen will understand where that came from. Now, let's move forward. We're going to get into the ex parte reading. Let's get to it. No more delay. I hope you guys are having an amazing 4th of July. You're out there with your family, loving each other, taking care of each other, being good to each other. You know how that goes. Let me pull up the document real quick. Again, thank you for being with Grace Levi, your hood court interpreter. You know I made up my own name. Yeah, whatever. That's why I say my own title. Okay. Now let me pull up the document. make sure that I have it. There we go. It's about to say where we at. So we did start reading this yesterday, and we can start where we left off, or we could kind of just start from the beginning. Okay, and I think I'm going to start from the beginning because yesterday we had the computer voice on and we were trying to test it out. So let's put it up. Shout out to our mods. I love you. Thank you for riding out with Grace Levi. We blow up together. You already know. I'm honorable. I love your support and I'm grateful for you. All right. My first mod was Miss Valerie. Thank you, beautiful. I hope I'm keeping you entertained. Now, let's get to it. We're going to put the transcripts on the screen. I'll play some music. Anyway, so now here you go. You have the transcripts up there, and we're going to get to it. I'm going to put myself a little bit more bigger on the screen. I want you guys to be active in the chat. Definitely leave your opinions, leave your thoughts, because I will be stopping and reading them and also putting them on the screen. Okay. It is what it is. It's a family affair. I'm not at the cookout. I'm home, so I'm gonna act like I'm at the cookout. It's a family affair. Once I get out of here, I'm gonna light up the bonfire, chill in the back, read a little bit, listen to the scripture. I'm gonna enjoy myself too. Okay. Happy holidays to the ones who actually, participate. All right, so let's get into this. This is the state versus Mr. Hughes, Kendrick, Nichols, Ryan, Stillwell, and Williams. Transcripts of the ex parte in the chambers of Honorable Ural, Glanville on June 10th. Can you hear me? Hit the like button. I'm going to break this down different. And I'm going to try to get through this a little bit faster. You know how I do. If it's laws that we should get into, I'll read them, but I'll just refer them to you. Okay, let's stick to the facts. There's no laws in this anyway. So the ex parte meeting started at 9:10 a.m. Present were Judge Glanville, Assistant District Attorney Love, Miss Bumpus, Court Reporter Miss Weaver, Investigator Antonio Long, and Rashid Hamilton. Okay, allegedly. And we know that it was more officers there as well, according to what Miss Bumpus testified. At least 4 and 2 detectives. Okay, so I guess these were the 2 investigators. Excuse me. So the court reporter. This is the court reporter. Okay, I'm ready whenever you're ready. Love, thank you. The concern that we want to bring to the court attention as the state was twofold. One, we want to have the opportunity to press upon Mr. Copeland with representation present that he faces, and we want to give him the opportunity to ask whatever questions he wants to ask before we we had. Now, mind you, when I stop, this is the reading. That's why I think some things are really missing from this transcript. So the court reporter, we love you, but something not right here. We had to pull him in the courtroom when the jury came out. The second concern, so basically her concern is that what he actually testified, and that she had to pull him out of the courtroom on Friday. The second concern that I have is that I want to bring to the court attention, in line with the concerns that I expressed on the record on Friday. I don't know what advice counsel may have offered or may offering. That is their right and their business as it relates to the testifying. However, I do not believe the criminal exposure is a concern that is within interest, is being spoken about in the protected. So Mr. Melnick relayed to Ms. Hilton on Friday, okay, and that is the prosecutor, on Friday, that he never heard the statute of 24-50507, and on Friday he sent the email. I don't know if he intended to copy Still on this email. Okay, so Still was, and the other attorney was copied in on this email that was sent by Mr. Melnick. Okay, so this is what I'm telling you. I think Mr. Melnick actually made them aware of this. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and the other lawyer with me and Simone copy where he said, "This is the communication that I received from Love regarding Copeland." My response was, "Whose interests are you protecting? Yours or Mr. Steele's? Yours or Mr. Steele's? Whose client? Which client are you protecting? Who client? Yours or Mr. Steele's or Mr. Shart's?" That's the other attorney. So basically, what he was saying in the email, Love had basically concern of what he was trying to say. Like, basically, who are you trying to protect? Them? Which one of them? Or you trying to protect yourself? Because of what you're going to hear, Mr. Malachi. Melnick. I keep wanting to call him Malachi. Melnick. Mr. Melnick says, okay, so my response is, who interests you are protecting? Yours, Mr. Steele's. Who client are you protecting? Who clients? Yours, Mr. Steele's, Mr. Shart's. He wrote back and said, you are going to get him killed. You have made him, you are making him a target. Fuck you. I had to say that with the tone. You have made him, you are making him a target. As quote, fuck you, from Mr. Melnick, is what he wrote in the email, because he was concerned for Woody if he testifies, because this is on open forum. As I mentioned, all of these gang people are out here. They want to know who's connected to who. And Woody was, what the prosecutor was bringing out was even more than what Woody was saying, and allowed them to put pieces of the puzzle together. So given that his concern is that by testifying, at least that one that he conveys to me in writing is not his concern, it has nothing to do with exposure from the state. And if that's his concern. So she's like, okay, well, we're going to disregard that you say I can get him killed. He has no exposure from us. He has no risk from what we're presenting him. We don't want him locked up. The court. Now, the court, when we say who's the court, that is Judge. That's Judge Glanville. Okay. So the court, he's being who's concerned. All right. And this is Miss Love. Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in the testifying. In fact, if he had concern that the testifying will get Mr. Copeland killed and he is not communicating with us, his communication with counsel for defense, it would seem that he knows of things or something that we don't know. But you know now. And this is why it was even more important for Steele to be there and anyone who received that email, because they were talking about direct correspondence that even went to the defense. Okay. Additionally, and I will let Ms. Bumpus tell, he said if Mr. Copeland testifies, he no longer represents Copeland, which is strange, because if you were interested in your client, then it will seem you will want to be there for him while he testifies. This is the court now. Well, he is on vacation this week. Miss Love, I understand. This is why he has Miss Bumpus here. And he has said what he said. And as I read the statute, the things that is, and I will read the statute about the particular situation. And I was reading our rules of ethic, rules of conduct for attorneys. And it is clear that if an attorney, if there's attorney -- there were two things that were happening. So mind you, I'm reading straight. There are dashes in here. So if you hear incomplete sentence, that's because the court reporter did not finish the sentences here. Okay. So you hear what Miss Love is saying. She's talking about the ethics of how the lawyer is supposed to conduct himself. Mr. Melnick, not in one time considering her behavior and what's been going on through the trial. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. So she's been told that he wasn't Mr. Copeland's lawyer by Mr. Melnick before. So she's put this on the record, and there's still an instinct that they're saying Mr. Melnick represents him. But he said he's not his lawyer. You see, listen to this. Mr. Copeland had told Miss Hilton that Mr. Melnick wasn't his representing him. So even Mr. Copeland told him that. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Sharps, and Mr. Melnick reached out to Mr. Copeland, injected himself in his proceedings. Now she's saying that email injected himself into the proceedings. Now, I don't know if Woody went to Melnick and Melnick just responded with an email mad, but this was what I assume it. So this is what they're saying. What were the discussions? Okay. What we were discussing was in no way matter Mr. Melnick was representing Mr. Copeland on. And that there was nothing, hold on. That is where we are not allowed to speak with the person when they are in representation by counsel. So basically what she's saying, what we are speaking about to Mr. Copeland, and this is a prior, and she's acknowledging that he had no representation at the time. She's saying what we were talking about, we were not allowed to speak with persons when they were not represented by counsel, but she wasn't represented. Mr. Melnick could not have been representing Mr. Copeland in anything we were talking about, because we were talking about this case and this trial. Now, this is indicating that the prosecutors had communication with Woody at some point way before the trial. And Mr. Copeland was not represented. Woody/Copeland was not represented by Melnick, by words of Copeland and Melnick, but allegedly Melnick sent this email. All that aside, this is still Ms. Love talking. All that aside, we would like the opportunity for the court to address Mr. Copeland and Mr. Copeland's standing representative, Ms. Bumpus, and then it says Ms. Bumpus is looking at me. It says Ms. Bumpus is looking like. So Ms. Bumpus then says, I'm listening. They put a little expression in there. They like, Ms. Bumpus is looking like, I'm listening. This is Ms. Bumpus. Now, Ms. Love says, with his standing counsel present, and to allow Ms. Bumpus the opportunity to explain to Mr. Copeland everything that I have just said. His concerns outside was with the longest he can stay in jail. What I relayed to her is that the statute says until he purge. The court, by testifying. So the judge intruded and said, by testifying, purge, testifying. Miss Love, his contempt by testifying. The court, 507 is a little bit different. So I mean, incomplete sentences. They didn't put everything that the judge said here. Okay, this has to be redacted on purpose. There's no way that they missed this. Miss Bumpus, so until the end of this is Miss Bumpus. So until the end of this, how long can he stay in here? And they're saying until he purged. The court, he can be here until the end of the trial. Miss Bumpus, that is what I said, to the end of the trial, the longest. This is Miss Bumpus asking. Miss Love, no, it's not the longest. Okay. Now this is, I believe, when Woody is not in the room. Okay, because I think that you're going to see in the transcripts where they go out or something and get him or talk to him, because Miss Bumpus is saying he's going to ask me what time, how long he has to stay here, because she already know he doesn't want to testify. So Woody okay, we about to be in jail for 2 years. I can do it. That's how serious it is that Woody was willing to stay in jail for 2 years. Miss Love, no, it's not the longest. Even after the grand jury, if a person has been subpoenaed to testify before grand jury and after the grand jury has what it is, convened, has left, the person can stay until the person purged himself of contempt by testifying. So even after grand jury, the proceedings are over. If the judge wants you to testify, you have to testify. The statute literally says that. So that's Miss Love. Ms. Bumpus, well, I'm going to look it up because it was my understanding that it was till the end of trial. Miss Love, nope. Here it is, literally the words of the statute. And so the court, he could be in there for a while. Let's put it that way. Either way, Gotta be retracted to me. I'm at, this is mine, because the court says, this is Judge Glanville, he could be in there for a while. Let's put it that way. Does it sound like somebody's working with Miss Love? Here goes Miss Bumpus. I just want to be able to give him something. The court, I know, it's kind of statute say, that you purge, but I can't keep him in there indefinitely. He said, I can't, allegedly. I got to kind of, is ... No more of detail of what the court is saying. Miss Bumpus, right. That is all that I want to know. Like, how long does he has to stay here? The court, the whole thing is that he has the keys to his own freedom, and that freedom is just giving his testimony. Then he's purged it. That's per Judge Glanville. Miss Bumpus, right. Miss Love, and whether that testimony is, who knows what we believe it to be, but we don't know what it is. We can't talk about it. You don't know. I mean, things are missing from this. I mean, we don't know what he's going to say. We have an idea. We know what he's told us. So she went from saying, we don't know what he's going to say. You don't know what he's going to say. We can't talk about it. But we have an idea of what he's going to say. And we know what he told us. So that right there highlights basically Woody concern of who's going to determine what's the truth when he's on the stand and what's perjury. You see what I'm saying? Miss Bumpus, yeah. All right. Miss Love. And of course, if this is our concern, I know the court says essentially you immediately, immediately that that Mr. Melnick probably told him essentially you should testify, that you're not going, they can't do anything with your testimony. So Ms. Love says, and our concern is that our concern is that if his, and I guess she's saying her concerns is that his or the lawyer basically told Woody that, all you have to do is, excuse me, essentially you should testify, and that they're not going to basically hold you in like contempt of court if you testify. So that's what she's saying. I hope that's what you and actually Mr. Melnick told him. So that's what Love is saying to her. I had to put that in perspective because the way this is kind of ridiculous. But what we overheard being said, on the contrary, Ms. Love said, but what we overheard being said, they are going to hammer you. And if we were going to expose Copeland, and she said, so instead of y'all telling him to testify, y'all told him that we gonna hammer him. Miss Bumpus, you heard that? Miss Love, yes, yeah. Mr. Melnick told Mr. Copeland, we're gonna hammer him. The court, now this is the judge. Now, to be fair, I think Miss Bumpus, as an advocate for anybody, has got to tell him he's going to face some pretty significant cross-examining. So the judge was like, well, I don't really find too many problems in her saying that. She got to tell him that he's going to get cross-examined. Miss Bumpus, yeah, I think that's what it meant. The court, I mean, he's going to face, he's got about 10. So he's like probably 10 lawyers that's going to be going against him. Either way, he's not represented on the defense or the prosecution side. Miss Love, so he meant the defense is going to hammer him. So that's what so he meant the defense too. Miss Bumpus, no, just in general, it's going to be a Miss Love, he knew that. He had already been expressing that. The court, this is the judge. But I mean, I think that if he's concerned about that, well, but it's all in the message, in the packaging of the term, I think. Mr. Copeland, a savvy person. He's a savvy person, but he is certainly going to be subjected to a thorough and spiffy cross-examining. So basically, that's what the judge say. And it seems like they know him. They know Woody's personality. Miss Love. And the other thing is that Miss Bumpus cuts her off. Can I just say something in the attorney Melnick defense and response, just for the record? Miss Love, yes. Miss Bumpus, the reason that he doesn't want to move forward with representation, what I have been told is if he decides to testify, it is that he does not feel like he does not know what was said outside of his presence, so he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. And that's the same concern that Still has. He needs to know what's going on so he can know how to represent his client. You can't just go in there willy-nilly and don't have a conversation with people and then like, my lawyer, this is what I said, this, that, or the lawyer wants to be there. He says nothing when you retain me. Does that make sense? So he was like, this is why you're going to hear Mr. Melnick basically says, if you testify, I can't represent you. And it's not because Mr. Melnick is representing himself or trying to basically save himself. He can't do it adequately. So now Miss Loves replies, but the thing is that the only thing that he should be concerned about is criminal exposure or exposure to Keith Copeland has criminally. And there's nothing. So he said only thing he should be concerned about is if he's going to go to jail. The rest of that, killing, dying, it has nothing to do with it, literally. This is what she's saying. There is literally nothing. The statute is quite clear that what we can do to him about blank blank. The only thing that would put him in harm's way is if he lied and refused to testify after being ordered to do so by the court. And again, you hear Miss Bumpus talk about, Miss Love talk about, well, we don't know he's on testify to, but we know what he told you, and we know what you don't know. We don't, all of that don't know right here falls under if he lies. And by lying, we don't mean like, oh, I think you're lying. It will have to do like, something, obviously, because we can always impeach. Because if he literally perjures himself, that's something different. So he said, well, if he said basically they can impeach or perjure him. Impeach happens, he won't go to jail. Perjure, he's going to go to jail. But if he literally perjure himself, that's something different. We can't help that. We can't control that. We will only say, tell the truth. I don't care how bad it is. Just tell the truth. And the more truth and the more he talks, the more people's life is in danger, allegedly. So, like he said, I don't go down to the police station, the court. Like he said, for instance, this will be where he can, inconsistent statements will be grounds for impeachment. If he continued to do things like, I didn't go down to the police station. He said, I didn't go down to the police station. They took me to the police station. You see what I'm saying? That's grounds for impeachment because we're inconsistent statements. So she kind of said that there. The court. And I take part of his, this is the court, this is Judge Glanville. And I think part of his challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here. So the judge is telling Ms. Bumpus what to do, how to handle her client. You need to reassure him, look, I'm going to be here. And if you think that they're going to ask you any questions, that's they'll begin the state or the defense is asking you questions that's going to bring out other crimes that you go into dash. He's going to be able to look at you and say, can I have a chance to talk to my attorney? He says, so all you got to tell him is that I'm here for you. That's what he's telling you. Tell him that. Miss Love. Exactly. Right. That's all you have to do. Miss Bumpus. Okay. Miss Love. See? But that is just it. Miss Bumpus. No, he's not. Just tell him he's not going to testify. Miss Love. Hold on. That is just it, Judge. The problem is that there being an assertion that people are representing. So basically, she said the problem is that the people who represented him, blank, 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 blank. And she's talking about defamation. She's defaming some lawyers right now. And they blanked it out. Okay, that's what she's doing and saying what the lawyer's doing towards him, for him. And they blanked it out. And it goes on to say, and I'm not talking about you. And that's what she said. What I'm saying about what they're saying is not about you, Miss Bumpus. And Miss Bumpus was like, okay. Miss Love. Okay, now this is Miss Love now. There's been an assertion. So he said there's this assertion that people are representing his the biggest concern is his best interest, and that that's just not the truth. And Miss Bumpus is saying that he is not in a position to do that. So he's saying they're talking about Mr. Melnick. That's who she's talking about. She's defaming allegedly Mr. Melnick and saying that he's doing it for his own benefit because he's on vacation or whatever, and that's why he want to pull himself out. It's not in the best interest of Woody and Mr. Well, I'm giving you the reason why Mr. Melnick pulled out. He like, I can't adequately represent you if I don't know what you say. I need to be there. Okay, so here goes Miss Bumpus. No, I'm not saying that. I'm not in the position. I'm saying that the agreement between Mr. Copeland and Mr. Melnick, who I'm standing in for, is that if you choose to testify, I'm going to get him to sign a paper that says that this discharge Melnick as representing that as per this agreement. And I can't do nothing about that. She's like, that's all I'm here to do. That's all I'm here to do. And she got pulled into this. Miss Love, that sounds weird. That does not even sound like something that Mr. Copeland and Mr. Copeland's best interest. That sounds like protecting someone else's best interest. If you're talking about, I can't blank blank, I ain't going to go into it blank blank. I'm not going to represent you. So she's some things missing out of there. I don't even know what to do with that. She's like, I don't even know what to do with that. What she was being transparent for and what a lawyer should do. It's like, well, what do you mean you can't represent him if you don't know what he said? Just don't matter what he said. We have what he said. You come and let us run a train on him, allegedly. Miss Bumpus, well, he said he doesn't know what was said. He said that's what he's saying. Miss Love, it doesn't matter what he said to us. Miss Bumpus, right. Miss Love, it doesn't matter. And he didn't even ask us. He didn't even inquire. What have you all talked about? He has been talking to Brian Steele and Max, the other lawyer. That is. And he's not talking to us. And in fact, nobody want to talk to them either, right? You see, like the other lawyer, Mr. Melnick, don't want to talk to their asses either. And in fact, Mr. Copeland asked to speak with us. Mr. Melnick barges in and gets between Mr. Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Hell yeah. He like, wait, don't talk to my client. I need to be there. And Miss Love don't like that. Miss Bumpus, well, I think what happened was, and I'm saying this because I previously represented Copeland previously on other stuff. So I know this is just what I think. So based on her representing Copeland and being involved, I think how attorney Melnick came involved was his representation of others because he took my place. Copeland fired me and hired Melnick, and then this came about. So basically, he was saying that Ms. Bumpus was Copeland lawyer in other affairs, and she ended up firing her on the other affairs and taking Melnick as representative on his other affairs. Mr. Copeland goes into court not thinking he needed a lawyer, and he ended up being held in contempt on Friday. So by Monday, he needs a lawyer. He has a lawyer. He calls Melnick. Melnick I don't know when he sends this email, but it could be between that time when Copeland probably got in contact with him over the weekend or the family. I'm putting my assertions in here because I'm making this make sense. So this is when Melnick is somewhere else. Copeland doesn't have an active case or hearing for anything that he's charged with, so he didn't need a lawyer. Melnick seems to be allegedly too going on leave as well. So I don't know if the cases that he dealt with Copeland is already finished and done, but Copeland must have reached out to Melnick while he was locked up. So at that point, Melnick not available. He sends Miss Bumpus, I'm saying her name wrong, sending her just in representation when Miss Bumpus was fired. She don't really have nothing to do with Copeland. She's just helping Melnick. Does that make sense? Does that clarify what happened? And then you will listen to the attorney's podcast, and she said she was going on vacation. She was her outfit, she was going on to getting ready to go, whatever. And she thought this was gonna be something short, and that's why she goes into saying, and basically she can't represent him. She don't got nothing to do with it. And the judge tries to force her. So are we making more sense of this? Hit the like button. I'm going to get through a few more pages. Do you like how I read it? I'm trying to change personality a little bit so y'all can hear it different. It sounds much better than the actual voiceover. All right. So now we're going to go into it. So Miss Melnick, that was the breakdown of that interaction. And this is Miss Love response. Miss Love, in his criminal matters that he had, but that's resolved. You see what I'm saying? Miss Bumpus, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. So I don't know if it was at the beginning of the case or when he just got in trouble on Friday. Miss Love, Melnick has never in life. Okay, so let's get to it. Okay, let me not add too much assertions. So Miss Love says never, Melnick never in life. Miss Bumpus, this is 2 years ago. He said this. Miss Love, Melnick didn't. As a matter of fact, so basically, I think the reason why Miss Love is assertion he never represented him, because the communication that she had with Woody was not supposed to happen without the presence of a lawyer before. Whatever interactions that they had before he stepped into court was not supposed to happen without the presence of a lawyer. And that's exactly why Mr. Melnick don't want to have anything to do with it. Does that make sense? And Ms. Bumpus is putting on the record that he been dealing with Mr. Melnick for 2 years ago. And Ms. Love, like, no, Melnick did not. As a matter of fact, less than 2 years ago, when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me I don't represent him. And people were in the room. He was on the speaker, and he told me he didn't represent him. Was it a paper put in, Ms. Love? No. I just added that. Now, he ultimately did come about to represent him, but when were they trying to get, I guess, like, she's trying to figure this out, like, when did this happen? Because there is so much procedure errors and wrong ethical doing right now. She's even seeing more mistakes on her side through this ex parte communication. Does it make sense, y'all? Now, this is Miss Bumpus' response. Something, yeah. Miss Love, Copeland was like, he's not my lawyer. He said, Ms. Love said that. Copeland even said he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then, Ms. Bumpus, are you talking about recently? Ms. Love. So recently, Copeland said that Melnick was not his lawyer. So Bumpus is trying to say, when did he tell you this? When did y'all talk? Because Ms. Bumpus trying to get caught up. She's like, okay, right. Ms. Love, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued, or at least stood for him on the bond and then on his subsequent pleas, was Melnick. So if you saw Melnick in all his other proceedings, why do you think he was going to call Melnick again? That he didn't have access to a lawyer, and that possibly you should not have been questioning him or talking to him. But this is continued down what Ms. Love is saying. But I don't know whose interest he would be representing when he's not talking to us about what we spoke about to Copeland. He could ask us and we could tell him. Right. You know, so I don't know why he would withdraw his representation of him. If he has interest in Keith Copeland, then why would you pull out? He says the court, that doesn't make sense. So the judge is agreeing with Love, Miss Love, at the point where he would face the most federal if that it is his concern. If his concern is that I don't know what they talked about, so I don't know what blank, blank, blank. They left that out. And the court follows up by saying, this is Glanville. And I thought that Miss Hilton had a list of questions for Copeland anyway. So he's like, I thought it was all like constructed already. Miss Love, she did. The court, well, how come y'all can't? He's not putting it. The court is giving them more suggestion on what they should do. Like, and he probably is blank, 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 blank. They are literally redacting what this can't be the full transcript. That's why we highlighted the damn court reporter today. We had to make fun of her because this right here is either redacted or she severely messed up. Now, this is Miss Love. Miss Love, he didn't ask to see those. He didn't. And not only that, redacted. I'm gonna just put redacted where it's blank blank. The court, well, you can't. You all share with Miss Bumpus. Basically, can't y'all just share the questions? Miss Love, well, Miss Hilton has already shared it with Mr. Copeland, and we certainly will share it generally speaking. So they're not even trying to give it to Miss Bumpus. The question is, Miss Bumpus, can I read the email that Mr. Melnick sent to me? I don't know if this will help you understand what he said. It says, hey, Kayla, I wasn't able to see Keith today. Kenneth, he didn't see Mr. Woody. He said he went in on Saturday and tried to talk to him before his flight, but I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the fifth. He may change his mind on Monday. If he does, then he has agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's going to sign this. And that's what Ms. Bumpus brung. So it seems like it was already a planned vacation for Mr. Melnick. Woody got locked up on Friday. He tried to see him on Saturday, but he couldn't. And at that point, all he could say is, listen, if you testify or you talk to them, I can't represent you, because I don't know what you're going to say. I don't know. And it seems like Woody like, okay, cool. I got to make the decision. Now, this is Miss Love. And that's just that. It's like you never know what someone's going to ask. And if he's concerned about putting him in legal jeopardy, this is Miss Love speaking, then he retracted. It would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal justice. That is not the original email as well. The concern for Mr. Melnick is that you're going to get him killed. Not legal justice. They keep talking about the immunity. You're going to get into that. But that's not Mr. Melnick's concern. Remember that. This is how they twist and mutate what's going on and continue just to focus on one thing when you said something completely different. Okay? Miss Bumpus, you can't switch how it gets called. See, so she's like, you can't switch that. That's not what he said. Miss Love, see, that's not Mr. Copeland's best interest. That's in the defense best interest. When you say switch it, how is that called? What does that have to do with anything? Miss Bumpus, I don't know. Maybe he's saying that he can't do it because he can't get a refundable ticket. This is Miss Bumpus. She threw that in. I don't know where that came from. Miss Love, this is Miss Love saying, This is not what he said in that email. Now you're going back to the email, what he said. But you're not saying that he feel like his client going to get killed. But she goes back to say, that's not what he said in the email to you. And that is not what he relayed to the court. And his concern has nothing to do with that. The courts, he was very much retract the statement. Miss Bumpus, I tried to go back and watch as much as I could. So Miss Bumpus like, listen, I'm trying to get caught up on what's going on here. The court retracted statement, and then it goes into tell me what he was retracted, that he was going on vacation. And I said, well, you inserted yourself in the case. I said, really? You need to come on Monday. So basically, this is Judge Glanville saying that he had contact with Melnick, and Mr. Melnick, the lawyer, told him that he's going on vacation, he can't be there, and that the judge said, well, I don't care, you need to be here on Monday. You inserted yourself, Miss Love, so he can't force Mr. Copeland to discharge him just because Mr. Copeland's decision to testify. The court, I think you are in until it's done. I mean, you know. And Miss Bump is like, who, me? What the hell? How'd I get? Oh, damn. The court. Yeah, I mean, that's just it. If he testifies, you've kind of got to retract. Ms. Love. And frankly, Your Honor, I know that if a person faces criminal contempt, that they are entitled to representation if they want to, just like he should be represented when you was giving him cross-examine or questioning him before he came into court. But we're going to shut up. This is being a civil contempt matter, okay? Now, the court, not necessarily. Anybody who faces contempt can get counsel, all right? I mean, you know, not anybody, but anybody could. Everybody could. But he's like, I don't want to disagree with you, Ms. Love. But if you face contempt, even you see that still had the right to a lawyer. That's why you have Miss Merchant come in and say you had a hearing and everything, and then you just found him guilty of everything. You can't do that without representation. So this is Miss Bumpus. I can't say how long this is going to take. Miss Love, it might take days. Miss Bumpus, so hold on. Yeah, it might take days. And Miss Bumpus like, oh my God, what is going on here? Like I'm caught up in here. Miss Love, this is her response. And see that this is just it. I don't mean retract. I think Miss Bumpus is put in a peculiar position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor. But ultimately, it seems that if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings, then our proceedings, because it's the court's proceedings, not yours, our proceedings, and that it is a problem because that has nothing to do with the best interest of Kenneth Copeland, and that has nothing to do with Kenneth Copeland exposure to testify. So basically, she's like, get him on his conduct. Don't even pay attention that he said that his client life in danger. He's not able to listen to what he tells you, so he won't be able to help him on cross-examine or nothing. No, just get him on a technicality because he's fucking up our proceedings. Excuse my language. That's what she's saying here. So just to answer the question, and this is continue, Ms. Love, just to answer the question about what he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court order or any information directly or indirectly derived from the statements, testimony, or evidence shall be used against the person in the proceedings or prosecution for a crime or offense concerning which is testified or produce evidence under the court order. So under this court order, they say even if they produce evidence that they can't go after Woody. But this is on the state level. That's the immunity he got. Remember that. And he says says everything he got on the stand and said. And that's if he just said everything, he'll be protected. The court, this is Judge Glanville. He started talking about the unrelated crime, which is what is the biggest thing I think he's probably thinking about is that a lot of stuff that could asked him about. So basically, one thing will lead to another, one thing will open another can of worms, and that's what Woody is afraid of. Not only for the crimes or the possible things that he can face as criminal, but on the streets. Everybody's watching this. So the people who had someone killed, found something else about, they're watching, and this is possibly why Tay got killed. Does that make sense? So this is the court. Again, he said he started talking about other unrelated crimes, and this is what's the biggest thing that I think he's probably thinking about. And the court is acknowledging that Woody is nervous about this. Judge Glanville is acknowledging this. And that's why I think Judge Glanville's tone totally changed, especially after someone passed away. It's going to be a little bit more. It's more to this. We're only on page 17. Hit the like button if you like how I read it, how I give my expressions to make it make more sense, okay? Miss Love, right, okay? That's it. Here goes the court again. That is not known to a lot of people, and that you retracted. You know, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime. So they're saying that, oh, now the judge is still trying to educate Ms. Bumpers and say, well, he can invoke the Fifth Amendment if it has something to do with a crime not related to the case. But everything that they put out is going to say is related to the case because it's RICO, and RICO is abstract. One thing led to another. One thing, it could be subjective, not objective. It could be a suggestion that you have connection with this, and then it's entwined in a RICO case. So it's very absurd to pull this Fifth Amendment right out. He would not be able to do that in particular instance. And this is Miss Love. But even if that, we wouldn't do it. We're not going to do that. The court, even that, he still has to testify. He's just going to testify. This is what Judge Glanville says. Miss Love, literally, right. The law says retracted. The court, yeah, I mean, anything he testifies to, retracted. Miss Love, retracted. We do this. Miss Bumpers, okay. And then about the delay or the stall, isn't it true or isn't it not true that he had a leave filed since December? So he's saying that Mr. Melnick have a leave that has been filed since December. I don't know what date that is, or maybe this is it, but this is the response from Miss Love. She like, I don't give a damn. Miss Love, we have nothing to do with any of that. He injected himself into this, and actually Woody pulled him into this, and he probably felt the way, just like how Still loved his client, I guess. He felt the way like, y'all about to get him killed. Okay, this is what I'm thinking. And the court like, yeah. See, the problem is retracted. Miss Love, he stepped in. The court retracted. Then we get involved. I don't know. You have a lead. Retracted. Miss Love, right. You retracted. I'm sorry it sounds like this. The court, this is Glanville, retracted. And unless you file the leave into this case, you don't have a leave for my case. Miss Love, right. Miss Bumpers, okay. All right. Miss Love, and he did not do that. The court, so he don't have one. Miss Love, Mr. Copeland's been a witness and a name on this witness list since retracted. The court, so since he said, well, I represent him, I'm like, okay, well, you don't have a leave that's filed in our case. So the court, Glanville is saying how in our case, oh my God. He said in our case, that is not your case. He is literally showing bias right here. I just caught it. So this is Judge Glanville getting in like, yeah, and this is what I told Melnick. He emailed me and I told him he don't have a leave and he should be here or somebody represent him, and that's why you here. You can tell the personal feelings into this. Our case. Miss Bumpers, okay. Miss Love, so he did this to himself and he did it to you. All right. That's why you're in here. But we have to retract it. You know, that is just where it is. And I don't know that retracted. That's just where we are. So she's trying to put pressure on Bumpus and just try to like ease her down. But like, well, that's why you're here. And now the pressure's on you. We're going to keep moving. Miss Bumpus, so judge, you are going to make me stay if he chooses to testify? The court, I am, because retracted, you're his lawyer. You're his lawyer. You stood in the lawyer at this point. Miss Bumpus, Your Honor, I don't have a problem with that. I'm just like, retracted. I'm not ready. Miss Love, if this is Miss Love saying something that's retracted, said she's giving her more suggestions to control the manner of the court. While the defense is nowhere around with this, okay? The court, there's nothing for you to really do or be ready for. I mean, here's the thing. This is Judge Glanville. I think the only thing you've got to kind of ask him is, look, here's the questions the state is going to ask you. All right. Is there anything else that could hurt you that they might ask about? And as long as you have knowledge of that, then I think that you are fine, because the state only going to get into this. Now, the reason you don't want to know what's going on to hurt you is the defense know more than Keith Copeland than anyone else. So he says, now the reason you want to know what's going to hurt you is the defense know more about Keith Copeland than anybody else, allegedly. This is the judge trying to reason her into feeling comfortable. So, and she's like, he probably like trying to hint like, you're good with the defense. So, because she already hint that they're talking to the defense and not prosecution. And this is the judge still coasting in this. So there are probably kind of retracted. All right. Ms. Bumpus, what about if they said, I can't do it? What if I said I couldn't do it? Then Melnix needs to come back, right? And I'm going to be in trouble because I was only in for Monday. And that's what I was told. And that was given specifics. I was given specifics of what I was going to do. Retracted. Miss Love, if Copeland said retracted, I don't know what Mr. Copeland wants. It's his choice. Miss Bumpus, can he say he doesn't want Melnick? Miss Love, he can say whatever he wants. It's his choice. Miss Bumpus, but the judge is saying blank, 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 retracted. Miss Love, I don't think that he can be forced to have representation if he doesn't want it, need it, or say he wants it, because we have offered. We have done everything to clear him of judicial exposure. He's not retracted. Basically trying to say his life ain't in danger. There is nothing we can say retracted. He could lie, but that puts him in, retracted, which is perjury. So basically, do you see how this is flowing? This is ridiculous. Now, Farrell. Now, the court says Farrell. Ms. Love says Farrell. But he can talk about the crime that he could then be prosecuted for. This is what Ms. Love says. The court. That is involving this or some other place. Ms. Love, right. Ms. Bumpus, I understand that. So he said he could talk about them other crimes, but that's for here in another place, basically. So the judge is finishing Ms. Love's sentence for her. Ms. Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. Ms. Bumpus, I would have to agree with you that I don't think that this is his concern. Isn't that what you said? So that's what she said. I'm trying to tell you that's not his concern. And you even said that's not his concern about being criminally exposure. So why you keep talking about it? Why is nobody talking about this man life in danger? So here goes, Miss Love. Well, the court said that blank, 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 retracted. Miss Bumpus, no, I was saying with Mr. Copeland not testifying, you said you don't think that his concern is criminal exposure, or you don't think that this is what he's worried about. The court, this is Judge Glanville. Do you think that he's fearful for testifying for other reasons, like for his personal safety? And this is where you have Mr. Glanville, the judge, acknowledging that, okay, it's something else with this man don't want to testify. He'd rather go to jail. but they're going to choose to ignore this. Let's keep reading. Ms. Bumpus, right. So let's read what the court said again. Do you think that he's fearful for his testifying for his any other reasons, like for personal safety? Ms. Bumpus says, right. Miss Love, that's not what Mr. Melnick said to me in any email I pulled up. He never said that. He said retracted. Miss Bumpus, but you don't believe that? Miss Love, retracted. You are going to get him killed. That's what he said. That ain't going to kill him. He said that's what he said. We ain't going to kill him. So Miss Bumpus like, we're not going to kill him. And she said she's basically changing the words to say that Mr. Melnick said that the prisons is going to kill him, but he's saying you're going to get him killed generally. So you see how Miss Love is she used technology so much. Okay, this is why we do this, so you can understand technology too. Miss Bumpus, see, I don't know anything about the email which you're talking about. Miss Love, we ain't gonna kill him. I can show you the email, but we're not going to kill Keith Copeland. So who is he talking about? So what are you trying to do? The court, this is collateral second and third order effect. You know, let's pray it doesn't happen, but retract it. This is the most two important places that I want to show you on this, because this is why I believe Judge Glanville tone change. After this young man, I'm going to put him on the screen, has died. This young man, we're just going to put it up there because I have to say rest in peace, Tay-Tay. I think that's in this transcript. This is the time prior to him dying that the judge knew that it could be some casualties related to Woody's testimony. Okay? Does it make sense? Welcome to Urban Politics, where you got Grace Levi breaking it down in plain text, helping you understand law interpretation. As a legal nursing consultant, all I do is research law, case law. I love it. And this is why I break it down in plain text for you guys. And I make it a little entertaining. Okay. Now, this is what I wanted to highlight, that there's a possibility that Judge Glanville had an inclination that some harm will come to the witness or have third-party collateral, which he states here. He says, Miss Love, we ain't going to kill him. I can show you the email, but we're not going to kill Keith Copeland. So who is he talking about? So what are you trying to do? The court, this is collateral second and third order effect. You know, let's pray it doesn't happen, but retract it. Miss Love, I mean, obviously he retracted. So she's probably acknowledging that he should have some concerns. He was in the gang. This is my assumption in this retracted statement. And this is the court that has the intro retraction. First, he has to give testimony, though, for any of that to even happen. And this is the court like, well, he has to give testimony. Let's just get back to that. I mean, that's what he has to do. He got to give testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Miss Love, so we would like, with the court's permission, they haven't brought him over. So Copeland wasn't even in all this time we've been talking. And he was supposed to be the first one up. So I guess they went to get him. They might be over there with him now, the court. Is he here now? Miss Love, I don't know. The judge exits the chambers at 9:30. Literally, they were talking all this time without Mr. Copeland being there. Miss Love, now, we would like to just go into another courtroom and talk to him. They want to separate him again. They want to start off by separating him, period. Give you a chance to talk to him and give you the opportunity to explain this to him. So they want, I think, Bumpus to talk to him at this time. The court reporter, we're off the record. So whatever they're saying right now, Love is telling Ms. Bumpus what she should do. And then went into a brief recess. They come back in at 9:30. Miss Love, this is Miss Love addressing Miss Hilton, and that's Miss Hilton is her buddy. Miss Hilton has been communicating with him, and so this is the prosecutor who has been communicating with him. Who is him? That is Woody. I'd like to grab her from downstairs and have her come up. The court, where is Copeland? Mr. Chamberlain, they took him upstairs to the tank in room 9. The court, okay, can we bring him out? Retracted. Can we retracted? Chamberlain, your chambers is being used. I mean, your court is being used. The court, let's bring him in here. He like, bring him in here. And Mr. Chamberlain, all right, so let me see if I can get that done. The court, let's bring him in here. Okay, thank you. We'll just bring him in here. The proceedings stood in recess from 9:34 to 10:03. That's when they went to get Copeland. Mr. Copeland entered the chambers at 10:03. Also present were Judge Glanville, Assistant District Attorney, Miss Hilton, Miss Bumpus, the court reporter, 2 investigators, Deputy Houston, Deputy McPherce, Sergeant Brown, the Sergeant Hill, and the Fulton County Sheriff Department. So I put 11 individuals plus the Fulton County Sheriff Department. I don't know who that is. 11 people marched Copeland in, or he came into being around 11 people in this situation, minus Ms. Bumpus being his representation. The court, okay, Mr. Copeland, can you let me know I got a hearing problem? He said, can you let me know? He said, can you let me know I got a hearing problem? So Mr. Copeland, Woody coming in on some bullshit. He like, I'm gonna let you know I can't hear. Okay, Ms. Bumpus, okay, he said, he said, I can. He is hard of hearing. The court. So he's saying that Woody's hard of hearing. The court, that makes 2 of us. I got a hearing aid, and that comes in the 27th of January. I mean June. So I'll try to talk loud. It's okay if Mr. Copeland, yeah, I can read lips. Is he deaf? Oh, I'll read deaf. And maybe don't let me be all starting feeling bad for Woody again. All right, so the court. Okay, good. Mr. Copeland, good morning. Mr. Copeland, good morning. The court. All right, I just wanted to bring you over and let you talk with Ms. Bumpers and see if there were any things that you needed to talk to your counsel or Ms. Hilton or the state or the courts before we bring you out to this morning, because it is retracted. We would like to hear your testimony, and that is kind of where we are at this time. So is there anything you want to ask? Mr. Copeland, well, I want to speak to you personally that I have never been truthful a day in my life. This is Woody. He like, I just want to start off by saying I have never been truthful a day in my life until I just made that statement right now. I don't comprehend none of this stuff that's going on. Tell me, Woody, slow. Right here in this statement, Woody is setting up a defense of basically not understanding or being competent for the procedures. Okay. Mr. Woody is smart. Okay. I've been noticed that, yo. So the court, okay. Well, the only thing you can give is a truthful testimony. I mean, whatever you know is whatever you know. I mean, it is that. Ms. Hilton. And what we will say, Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns that you have expressed to Mr. Melnick last week. But if you are, now last week, this is from Monday, and I don't know if it's over the weekend or she says last week. And you will hear that Ms. Hilton had communications with Copeland without Mr. Melnick being there. But if any of you are concerned dealing with being locked up for anything, you can't. We already told you that. Like, there's nothing like that can happen. And it says the feds, and that's retracted. Ms. Bumpus, well, that's not retracted. So exactly what I told you. He can be indicted on a federal level. And I think Ms. Bumpus said, well, that's not total immunity. I'm just adding more into this allegedly because these things has dash dash. Anything when I say retracted, it has the dash dash. Miss Hilton, it is true. Miss Bump is because basically Miss Hilton said, basically that's not true what you're saying. And Miss Hilton's like, well, it is true. Miss Bump is no, I said that's not his concern. Miss Hilton. So she's saying bump the charges. I'm not even worried. He's not even worried about that. Miss Hilton, if his concern is safety, we need to know that. Like that's not expressed. So we don't know what the concern is so that we can try to resolve the concern. How many times are you going to say that y'all going to kill their client? This is what I'm saying, Mr. Copeland. And I have had conversations with you before. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitation is done. The statute of limitation is done. And that is not totally true because the federal statute of limitation vary by case and crime. I mean, by crime. So that is not true, what she's telling him. So there is nothing like I researched this weeks again and again. Both these statutes of limitation for what you and I talked about, which is in 2015, are before are done. You cannot be prosecuted for anything testified federally or statewide. Immunity, period, which is not the truth. So if there is a concern that is none because of you cannot be prosecuted. The federal statute of limitation is 5 years. So anything in 2015, 5 years would have been in 2020. Anything statewide is 4 years. It would have been 2019. Finished. No criminality concerns. Next concern, what may happen in the streets? You know what we have talked about, what we can do as far as living in all of that. We have had this conversation. So I'm trying to express to you, we don't want you locked up. So she's just like, okay, if it's concerned, we had a conversation about your concern. So you know what we could do. And I don't know if that's pertaining to protective custody or whatever, but you can't put his whole family in protective custody because you see there's been a history of several family members' houses being shot up. So I'm trying to express to you, and this is Miss Hilton. What's his name? Yeah, Miss Hilton, dark skin with the braids. So we're trying to express to you that we don't want you locked up. We don't know how many times I have got to tell you that. What I got to say to you is that we don't want you sitting in the cab or wherever they got you because of this. You know what we want. You know you want to talk to me on Friday before you walked in the court. We weren't able to talk. If you still want to talk to me with or without Miss Bumpus, I'm here, but we do not want you in custody. So they're talking about when Mr. I guess at one point, I don't know where Mr. Melnick, when was he there? Was he there on Friday? Because there was a point that they said that Mr. Melnick, Ms. Love said Mr. Melnick interjected himself when the state was trying to talk to him, and she was mad about that. Okay. But this is Ms. Hilton saying, we don't want you in custody. You will not retract it, this order. So according to this order, I don't know if you kept your copy of the order, but this order says that you are immune from prosecution of anything. Literally, judge, you might want to close your ears for this. Do you hear this? If you confess to a murder on the stand, if you don't have any independent evidence outside of what you said on the stand, you are immune from prosecution from what you said. So she's telling, like, if you commit murder, if you say you commit murder on the stand, the only way that you're going to be prosecuted if we have evidence. So she's telling, like, well, if you say you commit murder, we're going to prosecute you. That's what she's saying in here. So again, I don't know what was being communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in the previous conversation with Mr. Long, as I said in front of Ms. Bumpus, and I told you that it is within the order to say. Okay, so let me just reread what Ms. Bumpus said so y'all can see, because Ms. Bumpus said if you say you killed somebody, they said, and if we don't have evidence if we don't have any other independent evidence outside of what you said on the stand, you're immune. Listen, you see that? So he's not totally immune. Listen, and she's telling right in front of his face if they're not paying attention. So the court interjects, this is Glanville, and that is direct or on cross-examine. Ms. Hilton, and that is on direct or cross-examine. The court. So if you are worried about what the defense may ask you because they may know your business, if they ask you about things that you might think might have the liability with, you can't be prosecuted for any of those, except if they have evidence against murder, as she said. Mr. Copeland, I got family members watching this trial, and I don't want my nephews and them hearing the things that I have been involved in. You think that's okay, Ms. Hilton? But I think that is a separate conversation you can have with them as an honest individual. Like, look, nephew, I done lived a life that I don't want you to live. Don't go through what I've been going through, quote unquote. But that's something that you have to do outside of being in jail, because that's better conversation you can have with your nephew in person. But they shouldn't have to come to the cab jail because you are being held in contempt, putting more pressure on him, using his family. You see the manipulation. You can have that conversation with your nephew tomorrow in person. You can have that conversation with them. You can have the conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing? It's like, why? She's saying we, like him and her on the same side. No, don't try to manipulate Copeland. Copeland said, but y'all did this intentionally. This is Copeland like, what do you mean? Y'all did this intentionally. And that is that immunity agreement. Miss Hilton, no, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Mr. Copeland, this is Mr. Copeland's response. You knew my child's birthday was next week. Miss Hilton, but what I did tell you when we met with one another, I said to you, redacted, you asked me, what is the one thing that is going to get me in jail? Didn't you ask me that? And what was my response? If you pleaded the fifth. And that is exactly what you did on the stand. So she told him that on Friday. Mr. Copeland, this is him responding. This is Woody. But what did I tell you before I got to this point? This is what he's saying. I told you the whole time Tuesday, Wednesday, Thursday. And they retract what he said. He's been telling them Tuesday, Wednesday, Thursday, before Friday came and they gave him immunity. He's been telling them that he was going to do the fifth, allegedly, because they retract this statement. You hear this? This is interesting. Hit the like button. Miss Hilton, but I told you were given immunity. No, you ain't tell him till Friday. Miss Copeland, and this is Mr. Copeland, that I was pleading the fifth. So it said blank, 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 retracted that I was pleading the fifth. And this is Mr. Copeland saying, I've been told you this day, that I was pleading the fifth. Miss Hilton, no, you did not. Miss Copeland, Mr. Copeland, and Miss Woody, I told you every day I was pleading the fifth. Every day. Miss Hilton, no, you did not. And we told you. Retracted. Mr. Copeland, I told you my concerns. Miss Hilton, and we said we can give you immunity. And you said you were concerned is what they knew about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. Mr. Copeland, so I didn't tell you I lied on them to get myself out of the situation. He said, so I didn't tell you I lied on them to get myself out of the situation? Miss Hilton, you said you were a liar. That's what you said. You said you were a liar. Miss Bumpus interjects. Was this recorded? When the hell did basically like when did this happen? Miss Bumpus is looking at them go back and forth, and she's like, what? Miss Hilton, no. Miss Bumpus. So she said, no, it wasn't recorded. Miss Bumpus, And did he ever say that Mr. Melnick was his attorney? Miss Hilton, no. This week, retracted. When we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him. When we met in the car, what car? Because Woody was not originally in jail before he came to testify. Woody came from his house and got in jail on Friday. When was the time that Miss Hilton and Mr. Woody had a talk in the car? And this is what is alarming to me that I brought up earlier to you. If Mr. Woody, if Woody had a talk with Hilton anywhere in his neighborhood prior to this, knowing that people were watching him, this could have catapulted some issues as well. Do y'all hear this? So, Miss Hilton said specifically, no, this week retracted. When we first talked, we first met in the car on Friday. We asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him. Now, let's use some contact clues. He said, what he said, I told you on Tuesday, Wednesday, Thursday that I was pleading the fifth. And that Friday, he pleaded the fifth and got held in contempt. So they can't be talking about the Friday that they sat in the car together. This has to be a Friday prior. Does that make sense? Am I assuming something not right here? Does that make sense? Okay, let's keep it going. Now, Mr. Copeland, no, I never said he's not my attorney. I said I haven't talked to him. Miss Hilton, you said he's not your attorney. You haven't talked to him. No, so he said I haven't talked to him. And Miss Hilton probably added, well, that's not your attorney in her head. Then we continue to have the conversation. At this point, when they knew that he possibly had an attorney, they were supposed to stop that conversation on Friday. And that's why Miss Love was like, no, the conversation that we had with Woody had nothing to do with something that a lawyer was supposed to be present for. You see now why Miss Love reacted like that at the beginning of the transcripts. Miss Hilton had the conversation with Woody. So Miss Hilton, but if you needed him, we could have said, if you have needed Mr. Melnick, we could have said okay, just call him. So, I mean, that is our position. They was like, when we were talking, if you needed him, you could have called him, but you didn't. We didn't want you. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is, it is your truth. Just tell the truth. But you just have to answer the questions. We believe that your answer is retracted. Whatever your truth is, it is whatever your truth is. We know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you're going to answer the question is however you're going to answer the questions. I know what you said before. And this is continue, Miss Hilton talking. I know what you said before. So this is when who's going to be the determination of lies when Woody talks? The prosecution. And if he lies in their eyes, it is perjury. So I know what you said before, and I know what you said later. I mean, I know what you said before, and I don't know what you're going to say on the stand because I never went into full details about any of that. But basically, she know what you said before, but I ain't telling you what you didn't tell me what you was going to say on the stand. But what I don't want is that you to sit there here in custody. Mr. Copeland, you did it. He said, you did it. Miss Hilton, I did not do it. You did it by pleading the fifth, Miss Hilton said. Mr. Copeland, you told me retracted, but you went to the judge with whatever the things called you went to him with. You told me that I can't retract it. When I asked the question, I can't say I don't recall or I don't know. You told me that if I plead the fifth, retracted, I mean something retracted, why would I plead the fifth to something I ain't do? And I said that you don't know what I said and what I ain't do. And then you was like something. I'm gonna make that make sense. This is Woody talking. And basically, he was like, so you said if I say I don't recall or I don't know that I could plead the fifth. You told me that. And now you're saying something different. And he said, and then y'all asked for this immunity. This is Woody. And then y'all asked for this immunity. And I was like, huh? What is this? It was something. And then Friday, retracted. Thursday or Friday came, and then y'all gonna tell me, oh, we went to the judge, and this is so you can testify. If you don't testify, the judge gonna lock you up. So basically, Woody was talking to them and kept telling them, I'm gonna plead the fifth, I'm gonna plead the fifth, I'm gonna plead the fifth. They needed to come up with a strategy to make him testify. So they went to the judge and say, hey, we're giving him this right here, immunity, this, that, and the third. And the judge accepted it on Friday. And I think it was Friday evening or something like that. We got to check that. Okay. It was Friday after or before. I don't know. I think it has to be before, but it was that Friday. Regardless, if it was done on that Friday, that is not timely. And that says a lot. Okay. So this is what Woody is saying. He said, then y'all came to me with this immunity on Thursday or Friday. And I'm like, what? Oh, we went to the judge and this is what you got to testify. Are you going to jail? Miss Hilton, right. But that was based upon what you retracted. She said basically what you said to us and now what you don't want to testify. That's what I'm thinking. Mr. Copeland, but I told y'all that. I told y'all that I don't want to testify that. I told y'all this plenty of times. That's what he's saying. Mr. Hilton, no, you didn't. Mr. Copeland, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. So he's like, you don't know what happened. I'm pleading the fifth to certain things. I'm telling you. And they're trying to convince him just to talk. Miss Hilton said, and I said, I don't know what happened. Only you knows what happened. And I said, this is Miss Hilton, but you never said I'm pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Mr. Copeland said, I told you, I said I'm going to plead the fifth. And you said retracted. What would you plead the fifth for something that you did not do? Copeland, like, I told you this plenty of times. This is ridiculous. Miss Bumpus, so if you didn't have immunity prior, is that what you are saying? That you feel like he didn't have immunity prior? So this is Miss Bumpus coming in. She's like, wait a minute. Y'all didn't give him immunity prior to all of this stuff? Oh, she's seeing the strategy kicking in. Mr. Copeland, immunity came Friday, right when I went to jail. Now we figure out when the immunity hit the case. Friday when he went to jail. I knew I saw that it was filed in the evening time. They didn't give him immunity before that. He's been telling them that he was going to plead the fifth. He's going to plead the fifth. Whatever he was going to say on that stand before he got locked up, it was going to be on Woody. Woody was going to not only incriminate himself, but also with criminality, but also incriminate himself in the streets. And that's why he pled the fifth. And Copeland says clearly in this ex parte communication that immunity came Friday right after I went to jail. Miss Hilton, the immunity only came after Mr. Melnick. So she's trying to change it up. Mr. Bumpus, hold on. Miss Bumpus, hold on. She's saying something not right here. Miss Hilton, the immunity came after Mr. Melkin sent us the email saying my client is pleading the fifth. That was on Thursday at 6 p.m. But as Mr. Cope and Woody been telling them for Tuesday, Wednesday, Thursday, I'm pleading the fifth. Ms. Bump is like, oh, okay, it was Thursday. Miss Hilton. So after that, that was epic. He is pleading the fifth. Miss Bumpers. Oh, Miss Hilton. We came and we got it signed. Miss Bumpers. Okay. Miss Hilton. And then Friday morning came. Miss Bumpers. Oh, okay. So we need proof that it was filed on Thursday because Woody's saying it was filed on Friday or presented to him on Friday. Do you hear what's going on? Do y'all see how corrupted this is? This is a great read. We are 32 pages in right now of 56. Please let me know if it makes sense to you guys. And, are we putting a clear picture here? Hit the like button because these are the conversations that we need to have. Go through these cases in lame terms, break them down in regularity, impartial, and from Grace Levi, the hood court interpreter's way. All right, you get videos and everything. So now let's keep this broadcast moving. We are 3 hours and 30 minutes into the broadcast. I guess we'll be finishing about 45 minutes or so because we still have about 20 pages. We're going to read this and then we're going to sum up this broadcast and then we're going to break it down into parts, okay? And they're going to be different parts. I think I can do 3 parts of videos for this. So let's get into it. Let's continue down this yellow brick road. Miss Hilton, so between Friday evening, Mr. Melkin reached out to us, said he was representing him. So, I thought you said Thursday, Mr. Melkins emailed you and said that Woody was pleading the fifth. So Thursday you knew. So, okay, now she's saying now she acknowledged on Friday, Mr. Melnick reaches out to us and said he's representing him, his pleading the fifth. And they probably like, it's too late, bitch. We already got it signed. Too late, motherfucker. He can't do that. Excuse me. That's what she said in her head. Miss Bumpus is like, okay. And when was the last time you talked to him before Mr. Melkins got involved? Miss Hilton, we talked to him earlier that day on Thursday. Miss Bumpus, okay. And then how did speaks inaudible to Mr. Copeland? So that is what she says there. Mr. Copeland says he called me. This is Mr. Copeland. This is Woody. So Miss Bumpus, that one that represents him. Okay, I'm just trying to get a timeline. So Miss Hilton, sure, right. So we have been talking since Friday. So I met Mr. Copeland last Friday, I think outside in the neighborhood. You see, I wasn't wrong. They met earlier outside in Mr. Copeland's neighborhood. How dangerous is that? To me, that is unacceptable. Then he came in on Tuesday for court. We talked briefly on Tuesday. All this time, he kept telling her, I'm pleading the fifth. I'm pleading the fifth. This is the times that he told her. And then on Wednesday, he came in. Mr. Copeland. And on Thursday, too. Miss Hilton. No, I think he only came 2 days. So it had to be Wednesday and Thursday he came. I wasn't here Tuesday. It was Wednesday and Thursday he came. And then on Thursday, once I left, it was when Mr. Melnick reached out to us and said, my client is pleading the fifth. And at this point is when we went to the next morning and got the immunity motion. So, but he's been telling you he was going to plead the fifth. But once a lawyer contacted you, you took it serious. We need to see the timeline of when that was filed. Okay. Now, and this is continued. This is Miss Hilton. So she continued on to say, and then we spoke on Friday morning. I handed Mr. Copeland the agreement and let him know that he was immune and that anything he said, we can't use it. And then Mr. Melnick came and then we went into court. And no, Woody said that you said, if I say I'll plead the fifth, I'm getting locked up. You try to make it seem like you said something nice, but you didn't. Okay, so Ms. Bumpus, so you are pretty much saying you didn't ask for this? Copeland, I didn't. Ms. Hilton, but we gave it. He doesn't have to ask for it. Ms. Bumpus, I know. I mean, he's just saying and is retracted. Ms. Hilton, right. He doesn't have to ask for it, but to alleviate whatever his concerns were, we gave him immunity. He doesn't have to ask for it. Ms. Bumpus, so if we would have had this retracted, I'm just saying this is so that he can understand it. I'm walking him through. So they retracted what she said. So if he would have had this, so if he would have knew about this earlier, Mr. Copeland would have been making different decisions or had a lawyer on hand earlier before all that communication of what he was telling her. Miss Hilton was like, Miss Bumpus, would he still have testified or would he have been able to plead the fifth? Wasn't that what he said? Miss Hilton, if he did not have immunity. Miss Bumpus, yes, I understand that. Miss Hilton, yes, he could have pled the fifth. And that's what he did that day on Friday. Okay. And allegedly, according to Woody, they filed and let him know he had immunity after he got locked up. But they saying they did it on Thursday night. You see how something not right here? Mr. Copeland, and the judge not saying nothing. And none of this, the judge is quiet. Remember, the judge is in the room. Okay. So Mr. Copeland goes on to say, that's what I'm saying. Mr. Bumpus, that's what he's trying to say. He's trying to say he didn't ask for this. Miss Hilton, but he doesn't have to ask for it. Now, that's why we have given it to him, because that's on us. So now that we have given it to him, it's an order. He can still choose if he retracted, if this is the road he wants to take. Then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried. And that's not just the 6. There's other ones. Mr. Copeland was like, I done did longer time. He like, fuck it. This Copeland, he like, I did longer time. I'm good. I don't care what you trying to say. I'm going to jail. This is how much he's concerned. Miss Hilton, all right, Mr. Copeland, I'm telling you that you're literally immune from prosecution from anything else you may say. That's it. So the choice is always up to you, but you want to put it on the road. The state does not want you in custody. What the state would like you to do is purge yourself from, and it's retracted. And this is when we go into perjury versus purge. And this is how Copeland continued to build the character of incompetent. And I don't believe he's incompetent. I think he's smart. That's my opinion. So Mr. Woody / Copeland says, what does purge yourself mean? He's like, wait, purge yourself? Perjury? Purge yourself? Miss Hilton, meaning that you are no longer in custody and that the way that you purge yourself is to testify. This is how it happens. And this is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that holds you is that you refuse to testify. This is the court. Finally, the judge says something, Glanville. So you don't have any questions and other questions. Basically, if you invoke your fifth, he's like, what other questions? Like, that's all you care about is that? Mr. Copeland, I don't trust it. I don't trust it. I don't trust it. I don't know what's going on. I don't trust nobody. I don't trust her words. I don't know what's going on, Your Honor. I'm confused. He's saying he's confused. Miss Hilton, this is your insurance. I don't know if you want to break that down for him. This is Miss Bumpus. Well, he doesn't want that, the court, but he's been given it. Here go the judge kicking on in, acting non-impartial. Right. You know, I'm being sarcastic. So here goes the judge, comes in finally, and he says, but he's been given it. So that's the challenge, Mr. Copeland, that if he did not give, if he was not given immunity, you could invoke your Fifth Amendment. But what the state decided is what the state decided is that they said your testimony is worth more than them at this point in time, and they really want to know what you have to say. So they have made a blank from the state's perspective. So that is redacted, that have made a decision to give you immunity so you no longer can invoke your Fifth Amendment right. He acknowledged what the state tactic was right here. He acknowledged that the rights of Woody is being taken away by this step. So he says you have to testify. So that's the difference in this particular scenario, is that they have taken away, well, it said redacted, well, you can still invoke your Fifth Amendment privilege. You still can do that, but the consequences of invoking is that you will remain in custody. So if you testify, you get out of custody, you stay out of custody until you are done. Mr. Copeland, and if I don't testify, I have to stay until when? He said until the trial is over. This is the court. Until the trial is over, until all the defendants have been, and that's retracted because he may have said something that he know ain't right. And he says, I got these 6 that has been right now, and there are another 6. And that was the 6 that we showed you yesterday that all pleaded not guilty to that horrendous plea deal. Miss Hilton, no, there's another 12. The court, there's another 12 or thereabouts, and they're still outstanding in various forms or other. Mr. Copeland, can I speak with her for a second? The court, yeah, sure. So that's when Copeland like, wait a minute, how the fuck long could this go on? Indefinitely? They talking about 12 people. So they take a break here from 10:17 to 10:33. Mr. Copeland, my question is, I can't ask you a question. Hold on, Mr. Copeland. My question is, and that's redacted. Can I ask you a question? The court is yes. Mr. Copeland, so my question is redacted. So what I was just asking her was if you ask me a question and you feel as if I'm lying about it, would I still get locked up? Copeland is smart. Woody is smart. Miss Hilton, no. If you, that's retracted. So you are saying you said, for example, I didn't talk to Demion, whatever his name is. Well, no, I can't talk about that because the judge is in here. And you are asking for examples. If you said before that the sky is blue, because she was about to say, well, if you said that you didn't talk to Demion, so he's admitting to speaking to whoever this person is, and she was about to give an example. If you admit to talking to him, then let me give you a better example. She said, wait. Okay. You are asking, for example, if you said before that the sky is blue, and I said to you on the stand, what color is the sky? And you said the sky is red. I'm going to say no. Back before you said the sky is blue. Is this what you are trying to ask me? Ms. Bumpus, so explain independent evidence. You remember when they talked about the independent evidence, if they have independent evidence related to what he does as far as murder? So Ms. Bumpus come back in like, okay, so explain about independent evidence. If he says he did something and you know he's not telling the truth, what happens? So that's something different. Miss Hilton, if he says he did something that he did not do, then that's the thing. Ms. Bumpus, if you believe he did not, so if you believe that he's lying about that, because so if he said I did this and you know he didn't do it and you believe he's lying about it, would you hold him in perjury as he's perjurizing? And that's what they're trying to say. Ms. Hilton, then no. If he admits to doing something on the stand, and Ms. Bump is like, because he said she is retracted. So Ms. Hilton like, no, it won't happen. If he admits to doing something on the stand, retracted. Ms. Bump is like, okay. Ms. Hilton, her interest statement is retracted, and then it says, and he did not do that thing, retracted. Ms. Bumpus said, oh, okay. You see how they blanking out what they saying? And here goes Ms. Hilton. Ms. Bumpus like, I'm listening. Ms. Hilton, dark skin with the braids, retracted. I'm going to say, is this the first time you ever said that? So it's a retracted statement, and I'm going to say it. So it's kind of obscure here. I'm sorry, there's a lot of retractions, but this is still making sense to you guys, right? So now this is Miss Bumpus and Miss Hilton going back and forth after Miss Bumpus talks to Woody. Miss Woody, and Miss Woody, Miss Bumpus, Miss Bumpus, and you have independent evidence proving it wasn't him. Then what? So what if he say kill somebody and you know he didn't, and you have evidence that somebody else did it? What you gonna do then? Miss Hilton, then nothing. What do you mean? Like, I'm not gonna do anything. Miss Bumpus, so then he will be fine? Miss Hilton, yes, but, and that's retracted. Miss Bumpus, so you are okay with him if he got on the stand and said something that wasn't true? Miss Hilton, no, I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what you're going to come out your mouth. I expect you to tell the truth. And if you say something that is inconsistent with what you had said before, then I'm going to ask you. I'm going to ask you about the inconsistent statement. But I expect you to tell the truth. What you going on the stand and do, I don't know. I don't know what you're going to do. I want you to tell the truth. But I will deal with you, not retracted. You saying something different in the manner that I normally do. He's like, I'm going to hand you. She's like, I'm going to hand you the same way that I normally do. Basically, I'm going to eat your ass alive, and I'm going to keep on asking you the same question like this is Russia. Like he said, Mr. Copeland interjects now and says, if I'm saying something different, right, it's retracted. So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I then told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I told them. So he's saying everything could be a lie. One lie make another lie, make another lie. If I say this, then that was a lie. What I said before, that's what he's trying to say. I damn if I do, I damn if I don't. Miss Hilton. Okay, so you can say I don't recall, and that's how that works. I don't recall. Miss Bumpus, and he can say that to every single question. Miss Hilton, I will hope that that is not the truth, because I think there are some things that you do recall and some things that you don't. But the things that you don't recall, you don't recall. And then I will go through my process of what I do. You know what she do. Y'all watch her in the court. You can talk to him about what impeachment is. That won't get you locked up. So basically, she's saying if he's saying inconsistent statement, that she's going to impeach him, not get him locked up, allegedly. And that won't get him locked up. Impeachment will not get you locked up. You can talk to him about impeachment if he says, I don't recall. Mr. Copeland, what will get me locked up? Just tell me what'll get me locked up. Miss Hilton, what did I tell you? Mr. Copeland, I don't know. I'm confused. Miss Hilton, what you did on Friday, I plead the fifth. The court instructs you in that was redacted. So she said that what you did on Fridays was going to get you locked up. Mr. Copeland, so the only thing that gets me locked up is pleading the fifth? That's the only thing? Ms. Bumpus, yes. The court inserts, this is Ms. Hilton, the court instructs you, you need to answer the questions. You say it again. I plead the fifth. Again, retract it. That's what's going to get you locked up. But if you answer the questions, that will not get you locked up. This is Mr. Copeland. So if you don't want me in jail, why you just don't let me go after the trial's over? Okay? You don't want me to jail. Miss Hilton, you are in jail because you are not answering the questions. The court, because you have been given immunity. There you go, Gainesville, jumping itself in. Miss Hilton, because you have been given immunity, you are only in jail because you got up there retracted. Mr. Copeland, this is the response. Well, what about this? I answered the question and you take away my immunity. I answer the questions and I'm pleading the fifth. Okay. Miss Hilton, no, is retracted after that. Mr. Copeland is a little bit retracted. It says, to question that I feel incriminating me. He says the questions that I feel incriminating me. So he said something before that. And then he says the question I feel intimidating me. That's when he's going to use the, I guess, plead the fifth. Miss Hilton, but then that's retracted. because she's giving him law. She's giving him counsel. And this is terrible. This is a terrible ex parte communication. This is terrible on its face. Okay. Now, Mr. Copeland, I won't plead the fifth to things that don't incriminate me. The court, this is Gainesville. The state can still give you immunity. They can give you immunity whatever they want, okay? They can make that choice. I don't even make the choice. So if they redacted, like I said earlier, they want your testimony. They figured it redacted, that the jury needs to hear what you have to say, good, bad, or indifferent. And what Miss Hilton is telling you is just tell the truth. And you know it, and let her worry about redacted. I mean, even though you may have said different versions of whatever, that's for impeachment. So he's still guiding the witness and giving him law. And that's Miss Bumpus' job. That's not going to get you in trouble. Now, this continues Glanville. What will get you in trouble is that you not redacted, is you just invoke your Fifth Amendment privilege because you have been given immunity. Or as Miss Love said this morning, remember, Miss Love said, if you lie, if you overtly lie about something, it's like you're telling a bold-faced whomper, then they can indict you on that particular charge. I mean, that particular false statement. Mr. Copeland, that's what they're going to do. He said, that's what's going to happen. You're like, yo, this is a setup. Miss Bumpus, that is what I'm saying. So Miss Bumpus is like, that's what we're saying is going to happen. You will be right back here. Miss Hilton, but if you say something that you know you did not, like you admit to something you know you did not do, whatever, retract it. Mr. Copeland, like murder don't have, like murder don't have, like no statute have limitations. So basically, like murder has no statute of limitation. And that's what you were saying earlier. If he said something about murdering somebody, they got the evidence, they could prosecute him. So it's not saying that he said he murdered somebody, but he said like murder. Okay, Miss Hilton. But if you didn't do it, I can't charge you with something you did not do because I don't have any other evidence but you saying it, Mr. Copeland. But y'all don't like, and it's retracted. Miss Bumpus, you can charge him with false statements. And this is Miss Bumpus coming in trying to give him. She said, but you can charge him with false statements and he will be back in jail. That is what I'm trying to say, Miss Hilton. But if I know that you are lying about that, I don't intend to do that. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for that. But I'm not going to charge you when I know that you didn't do what they're trying to say you did now. And that can be the part of this. I know you didn't do it. So she's trying to play mind games with him. Okay, this is Miss Hilton. Girl, that's the devil who come with the gift of gab. Instead of her being like so aggressive, like how Love is, Hilton is manipulative. And she'll keep asking you questions different ways so you can try to answer it and get what she want out of it. That's Miss Hilton. Now I figured out her character because I could not figure out her character. Now, Miss Copeland, but it's up to the judge to do this, right? This is Woody. Miss Hilton, no, it's actually up to the state to bring the charges. The court, no, I don't have anything to do with that. Miss Hilton goes on to say, he has nothing to do with bringing charges. That's up to the state of Georgia. Mr. Copeland, can I call my family? I will make the decision right after I hang up the phone. Miss Bumpus, he's saying he hasn't even been able to speak to nobody. Miss Hilton, his sister just called us and it says she and then it retracted. Mr. Copeland, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number. Nothing. No, nothing. And Mrs. Hilton says, we have no knowledge. We didn't know that. Ms. Bumpus, he hasn't been able to do anything, speak to nobody. Miss Copeland, Mr. Copeland goes on to say, the jail system is down, but y'all still putting people in there. And that goes back to Fulton County, Guantanamo Bay jail. That's what they're talking about. Okay, Miss Hilton, that part I don't know. I don't know. We have been in communication with your sister. Your sister actually texted me to make sure that you was okay. We told her that we physically laid our eyes on you. I leave it up to the sheriff. I don't know. That's just like a brief pause. Mr. Copeland, so what do you think what she said? He said, so what do you think what she said? What she's saying? This is Mr. Copeland. And then Miss Hilton says, I can't tell you right now. I can tell you right now. So I guess he was like, what did his sister say? Like, what's up? What my sister say? And then she's like, I can tell you right now. And Mr. Copeland, I'm talking about that looking me back up. He said, no, and then he goes on to Mr. Copeland moves on after she said, I can tell you right now. And now whatever she told him, that's not what he wanted to know. He asked her, I'm talking about that locking me back up thing. And Miss Hilton says, we would have to bring charges. There will be no incentive right now. And he was retracted. Copeland, y'all will. Y'all do it. And they'll probably try to connect it to the RICO charge. And Miss Hilton says, we already had this discussion. Mr. Copeland, look what you did to me. You waited until Friday and did this. I done told y'all every day before Friday coming that I was pleading the fifth. Miss Hilton, no, you did not. As a matter of fact, our last, and she goes into something, the court jumps in, and that's Glanville. Now they seeing the pressure, he's seeing the coercion. He already went over the fact that this man life may be on the line. The man already saying, how long? 2 years ain't nothing. So the whole court is done. I'm good. They thought about 12 people. Goddamn. Let me talk to you, Miss Bumpus. And now here goes the court right back into, let's see what Mr. Glanville has to say. Mr. Copeland, let's see if we can get beyond this, okay? Beyond what is your concern is. You could have invoked your Fifth Amendment privilege. The state could have turned around and said, stop, and had me blank, go ahead and file the motion to give you immunity. He said, so even at that time, they could have did it in the middle of court, allegedly. It was going to redact it. I mean, they make that decision. He's like, it's going to happen regardless. So it don't matter when they did it. The judge is still siding with the state. They decided to make it on Friday. Do y'all hear that? The judge now admit that the decision was made on Friday, and Miss Hilton plain out lied and said that they did it on Thursday night. Oh my God. Now Miss Hilton is a liar and a deceiver. Now I don't like the dark-skinned lady. Now I'm mad at her. I didn't have no bias against her, and now I'm pissed with Miss Hilton because she lied. She said specifically that they filed the paper on Thursday when she got the email from Mr. Melnick. Remember when they finally took the statement as being face value that he was pleading the fifth after Woody said it so many days? Y'all remember that, right? That's why we're breaking this down. This is ridiculous, okay? So this is the judge to continue to go on. They made the decision on Friday. So even if you would have been comfortable testifying and invoking your Fifth Amendment privileges, they could have decided you as a witness, they wanted your testimony more than do you invoke your Fifth Amendment privilege. So they gave you immunity. They gave you immunity. So you got to testify truthfully as to what you know, your knowledge of the particular incidents is. I mean, so they're going to redact it. They could have done that anyway. This is the judge still pressuring them. Even if they put you on stand, like put you on notice, they could have said, stop. If he was right there as a witness, I'm going to ahead and give you immunity. They could have done that, and the judge would have let them. Mr. Copeland, so I can get it in the same type of writing that if I was to testify that if she feels as if I am lying or if I lie about anything, that I won't lock me back up. He's like, could you put that in writing? Because even if they feel like it, they're going to lock me up. He's like, whatever you saying, let's just get back to this. I want this in writing. The court says, let me have that, Ms. Bumpus. And Ms. Bumpus hands the document to the court. Brief pause. They must have put something in writing real quick. Ms. Bumpus must have moved fast. The court, Mr. Copeland, on a 2-page of order pursued. However, no testimony is given by Keith Copeland is required under the order, or any information directly or indirectly diverted from the testimony of Keith Copeland given by Keith Copeland as required under the order shall be used against him as Keith Copeland in the proceeding or pursuit for the crime or offense concerning which to testify under this order. So this looked like it was an amendment or something that she did. Okay, so you testified about some aggravated assault or murder. They can't pursue you on it because that is what it says in the order. Okay, and then murder has no statute of limitation. He's lying because they already said if they have evidence, if they don't have evidence of the murder that he admit to, then they won't pursue him. So what does it mean on the other phase? Okay, so the only thing that will get you in trouble, and this continues, that this is the judge interjecting, is the next little paragraph. Keith Copeland shall be subjected to prosecution or to penalty or forfeiture for any of the perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, if in the order that Keith Copeland shall not require to produce evidence that can be used, it says, however, it is ordered that Keith Copeland shall not be required to produce evidence that can be used in any other court in any situation, the United States or other states. That didn't say that it can't be brought up in any other proceeding. It just said that he couldn't, he's not required to produce evidence. Oh, that's a trick right there. That's a fucking trick. That is a trick right there. Oh my God. Did y'all hear that? They try to trick him. So basically, if you commit perjury, false swearing, or a contempt committed in testifying, that means you just invoked your Fifth Amendment privilege and failed to testify, and you say, I'm not going to testify. All right. So the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. Now, as Ms. Hilton and Ms. Bumpus has earlier stated to you, you may have told or been asked about situations over and over again. They may have been changed. What the state is asking is that you tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. Copeland, you said I will. Because Copeland's still confused. Like, what? You said I'll get in trouble. The court, you will not. You will not. This is the judge. Impeachment is not perjury or false swearing. So he's now trying to teach Copeland what impeachment is, when that is actually Ms. Bumpus' job. Okay, this is the judge literally working with the prosecution. Do you hear this all through this document? We are on page 46. We're almost through. Okay, please hit the like button. So he says, you will not. Impeachment is just perjury or false swearing. Okay, but impeachment is not perjury or false statement. Okay, so Mr. Copeland, but she said I can purge myself though. And this is where incompetence come in at. And he's like, but you said I could purge myself. So what you talking about? And Miss Hilton said, no. We're saying two different things. Sorry, stop. Just okay. Perjury is if you get on the stand and you say just a bold-faced lie, just something that is just wrong. Say you said I did something, and all the other times you have said I have not done it. And really, while it's perjury, it's really just an inconsistent statement. So they're going to pick and choose what's perjury and a lie, it seems like, because you can't, it's a thin line between perjury and inconsistent statement, as you can see. It's like if you get on the stand and say, I did X, but in 2015, you said, I never did X. This is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015 you said that. So this is when someone else enters the chambers. Lucinda Dean, we have a security issue. We need to stop the meeting for a minute. It stopped for about 2 minutes, and Glanville goes out and come back. So this is Lieutenant Dean. Okay. Now, so it starts back up. Miss Hilton, I don't know what was told to you on Friday. And you know, Mr. Melnick said they're going to fry you. Okay. And if you go in there and talk to them, I can't represent you. But she's trying to say, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want to do that to you? That doesn't make any sense. I said to you before, I will say it to you again in front of all these people. That does not make sense. Mr. Copeland, you just said I'm going to have to stay in jail until the last. And he like, man, please. You just said I had to be. So you added 12 people to this. Miss Hilton says, if you don't testify, he says, get that part through your head. If you don't testify, that is the only thing that is going to hold you. That is literally the only thing that's holding you right now is the fact that you keep saying, I'm not going to testify. Well, you haven't said it today. I'm not testifying. I plead the fifth. You get up there and that is redacted. I want you to tell the truth. Like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you to do is answer the questions so we can get through this, so you can go home, be with your baby for her birthday. So these dog drivers. Hold on. Let me just go back because y'all know I've been reading a lot. This is what freaks Copeland out. Let me reread this. He says, but what I do expect you to do is answer the questions so we can get through this. So you can go home, be with your baby for her birthday, see these dogs deliver their babies, go talk to your nephew, and do all these things. Mr. Copeland said, how you know about my dog? And she said, because you told me. And Mr. Copeland like, okay. And Miss Bumpus is like, what's wrong? What happened? Well, like, what's wrong with you, Mr. Copeland? Mr. Copeland says, I'm stressed at a whole nother level right now. Like, this is crazy. Miss Bumpus said, I mean, can he, I'm saying, Mr. Copeland, I'm weak. Man, I can't, I'm not playing. I'm dead serious, man. Like, yo, this is Copeland. He freaking out because it seems like Miss Hilton possibly has been watching a little closer than what he expected. He said, how did you know about my dogs being pregnant? He has the streets watching him. He has the DA watching him. Miss Hilton, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you know, you have to make, and that's retracted. Ms. Bumpus, if he decides in 2 weeks he wants to testify, then what? Ms. Hilton, if he wants to stay in jail for 2 weeks, then that's redacted. I don't know. Why would you want to stay in jail for 2 weeks? I have no idea. Ms. Bumpus, he just feels like he's under a lot of pressure right now. Like this second. Pressure, coercion. He's saying in front of the judge. The judge is saying nothing. Copeland, even at the jail, they're just like, you can't give me house arrest. So he's like, even at the jail, my life is going to be in danger. Either way, like, you just give me house arrest or something. Let me think about this. Ms. Hilton, no, you can go home by taking the stand and testifying. And that's what and it's redacted. And you know that jail is dangerous. We talked about it. Now, they don't give a damn. They don't care because they don't have to be in it. Ms. Hilton, there's no, and that's ridiculous. We keep on saying yet, but there is no crime. We keep on saying yet. I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not purging. Mr. Copeland, so why am I in jail then if I didn't do a crime? Ms. Hilton, because you're not testifying. Mr. Copeland, But that ain't nothing wrong. That's not a crime. Miss Hilton, it's not a crime, but you're in civil contempt. The court, there goes the judge chiming in. Two things, but you invoked your privilege after you were given immunity. That is why you are in custody, because you got out and testified. No, because you got out by testifying. So you testify, you get out. You see how the judge is literally fighting for the prosecutor. He knows that Mr. Copeland was given immunity on Friday evening, and he's acting like it happened on Thursday or earlier. And he's saying, Copeland, you messed it up while you went on there and testified Friday. That's why you were locked up, because they gave you immunity. You see how he's switching it? They gave him immunity afterwards. Mr. Copeland never knew of no immunity. Or I think he did. What did they say? They said that no, he didn't know of the immunity, because before the court case, Miss Hilton says that before he went on the stand, Mrs. Hilton said that he was going to talk to her, but the lawyer cut in, and Miss Love was mad about that. You remember? So he still never knew about the immunity till afterwards. Does that make sense? Wow. This is crooked. And the judge is trying to cover and misconstrue the words. So continuing on what Mr. Glanville is saying, which is the court in this document, that's why I was going to bring you. Retracted. I brought you here earlier today. I just want to inquire about that. You can remain and hold your position and invoke your fifth or not testify, but you're going back to prison. You're going to jail, because that's redacted. So the judge put more pressure and said, you're going to prison, you're not going home. He said, Mr. Copeland, Miss Woody said, basically, you can't sentence me. Miss Bumpus says there's no sentence. The court, there's no sentence. The contempt is compliance. They want your testimony. That is all they want, whenever that may be. Mr. Copeland, I don't know what this is, Your Honor. Miss Hilton. So listen, you are in jail for failing to testify. The court, failing to testify. So he comes behind. This is Judge Glenn and say, yeah, failing to testify. Miss Hilton, not for nothing else. There is no crime. You ain't do nothing. You don't know if people are telling you what we are going to charge you with, and that's with nothing. We're not going to charge you. The state didn't charge you. There is nothing we're going to charge you with. You are only in custody because you decided not to testify. This is it. Once you decide to testify, redacted. This is the court coming in behind them. Remember that word you were talking about, purge. Mr. Copeland, like, this is the court and this is the judge. Okay, you can purge right now. Purge. Get yourself out of jail. Just testify. Coercion. Copeland, I can purge? I can get out of jail? I can purge? The court says, yes, just by testifying. Miss Hilton says, not perjury. Because Miss Hilton knows Copeland. She said, not perjury. The court says, purge means that you can get out of jail. You can get out of jail, out of custody. Just testify. This is Glanville. Mr. Copeland follows up by saying, and what about the other one? What about the other word, perjury? The court says that's different. Miss Hilton says that's different. The court says that's a different word, okay? So that shows that Woody is setting up a case of incompetence. All right? And that sometimes can make you sit in Fulton County Jail indefinite, allegedly. Allegedly. Watch our other broadcasts. So, Mr. Copeland follows up to say, that can get me back in jail? Hilton says, yes. The court said, perjury will. Hilton, it's not redacted. what you are saying is not perjury. It's what you are saying and what we call prior inconsistent statement. So he says, your example that you gave me, what if I said something like, I don't know, you didn't do it. And you said before you did do it. This is not perjury. This is a prior inconsistent statement. And they all stop because everybody's confused here. Like, is that perjury or inconsistent statement? Fuck. They didn't say anything here, I think. This is ridiculous. And they're confusing him. Okay, so Ms. Bumpus, you've got to make a decision. If he starts testifying today, he's going to go home. Ms. Hilton, he should, so long as he remain. But if he gets up there and be like, if you get up there and testify, and then we get into, and you start saying, I plead the fifth, we're going to be back here again, Ms. Bumpus. But what if he says that he don't recall to everything he'll be asked? Is that okay? Ms. Hilton, I'm not advising that, but so long as he answers the questions, that's fine. So as long as and that's retracted. I did, and then Mr. Copeland says, I did these crimes. I'm telling you that. Miss Hilton, okay, I don't know what you're talking about. So Copeland is admitting to doing some crimes or something in this. And Miss Hilton, like, I don't know what you're talking about. We're going after YSL. We're going after them. I don't know. Whatever you say on the stand is what you say, and I'll handle it then. Miss Bumpus comes in and say, I think, and that's redacted. Are you saying you want to get up there on the stand and say something? Mr. Copeland didn't respond because he like, damn, like, wait a minute. Because he's stressing now. He like, wait, did I just say that I did do these crimes? Wait. Miss Bumpus, did we find out if he could talk to his family? No. And they all pause. He still not talked to nobody all this time. Miss Hilton, I mean, if it's okay, we got the sister's phone number. Mr. Copeland, Mr. Copeland, as my attorney, you gotta, and that was redacted. Miss Hilton, let me, and that was redacted. If y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. So they want to talk to each other, and he's not walking out the room. The judge is on one side of the room, and Miss Hilton's like, let me just walk away. They still can hear everything they say. This is terrible. The court, and this is the judge, said, hold on. Judge Glanville handed a document to the attorney, Caleb Bumper, and in the chambers with Assistant Director Attorney Hilton, Investigator Long, Investigator Hamilton, and Court Reporter Waiver from 10:53 to 11:29. So judge handed a document to the attorney. So it seems like from 11:53 to 11:28, something was happening. Maybe they were talking, Ms. Bumpus and Copeland. So at this time, okay, we're getting to the end. Okay, all right, this is the court. Mr. Copeland, have you had the opportunity to talk to Ms. Bumpers, your lawyer, and Ms. Hilton, the state counsel? Have you got any other questions? Mr. Copeland, no, Your Honor. The court, is your desire to testify today? Mr. Copeland, yes, sir. The court, okay, all right then. Do you all have some clothes for him? Miss Hilton, I don't know. Let's go take a look. And they start to look for some clothes for Mr. Copeland, Woody, for him to testify. And that's when you get everything that happened that we showed you yesterday. All right. That is the full ex parte transcript. Perjury, yes, equals lying on the stand. Purge is to snitch. But they were confusing him with perjury and inconsistent statements. So it was hard to determine what they would actually move forward on because they were so wishy-washy in their examples. You see what I'm saying? They were literally setting this man up. They set Woody up. This is Woody. So we're going to put who Woody is. This is Woody. This is when 2015, when he talked to the officers, and that video went viral, and he was just talking like a woodpecker. He's much different. This is Tate. This is the young man who was unalive in Atlanta over the weekend, possibly connected to this trial. Again, this is a full breakdown of the ex parte transcript, as well as a full comprehensive breakdown of what's been happening. I do hope that you guys enjoyed this 2-part series. This part is 4 hours and 30 minutes. We're going to break it down so you can just have the ex parte reading, and then we're going to break it down where we're going to have just a few sessions. So with that goes to say, I want to tell you guys, I love you. Thank you for being here with Grace Levi. Hold on. Thank you for being here with Grace Levi. I think I don't want that on the screen. I do apologize. Thank you for being here with Grace Levi, spending your holiday with me, building, learning, being entertained by this YSL trial, because this is something that we're all interested in. I hope I was able to break it down in lame text and give you more details behind what has happened. But until then, I want to send love and peace to Tate, the young man who was unalive in Atlanta this past weekend. Let's put it on the screen.
Police shooting in southwest Atlanta happened early this morning at an apartment complex. Channel 2's Brian Mims is live on Peyton Place. Brian, police say the shot was fired from outside of the apartment.
Exactly, and police say they don't have many details about what led up to the shooting, but there is a big police presence here at Peyton Place, just off Martin Luther King Jr. Drive. You can see the officers still on the scene after more than 3 hours. The call came around 3 this morning, and when officers showed up at an apartment at 9 Peyton Place, they found a man in his early 20s who had been shot to death. It's unclear if anybody else was inside that apartment, but police say there were no other injuries.
Yeah, let's go.
I already took 5 books. Be to yourself. Stay to yourself. Trust nobody. Trust nobody.
Hey, yo, this is going out to Moo Grandma. Definitely going out to Moo Grandma. One love, rest in peace. Let the angels take it. Ain't nothing wrong with a nigga getting his paper. Ain't nothing wrong with it. Don't hate on it. Listen to the song. Listen to the song. Still waiting on the world to come. Waiting on the world to say us. Every time I saw now that I reminisce on my reflection, close to perfection as a nigga can get without protection. You never tripped, and even though we had our fights down there every night, I'm cussing and fussing like it's impossible to get it right. Time alone, away from home, cause I can do that on my own. Looking for more than just another bone. Well, I'll be happy now I'm grown. It seems we have a problem with jealousy, cause you interrupting while I'm on the phone. I got some business to handle, so baby understand. Can spend my whole life up under you, I'm a grown man. Could you respect me if I wasn't dripping all up a prison or even worse?
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long.
I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Why are you detaining me? You about to lose your job. You about to lose your job. Get this dance. You about to lose your job because you are detaining me for nothing. You about to lose your job. You about to lose your job. Get this dance. You about to lose your job.